Good morning, everyone. Welcome to our first meeting of Joint Judiciary for the 2024 interim. Our staff is here and been here for a while. They were here early getting ready, so we're up and ready to roll. Senator Case is here, so now we're ready to really get after things. We have a lot of good topics this interim. I think some of them are particularly interesting, but they're all important to somebody. Some of them are more challenging than others. Some of them were topics that were proposed by members of the committee. Others were assigned to us from Management Council, and some came from folks outside the committee that asked the committee to take up some of these topics. So we will have a full interim ahead of us. We'll get started today, and then we will have our second meeting in September to give our staff time to get a lot of work done between now and then. So I just want to say welcome. So we call the roll.
Good morning, Mr. Chairman. This is roll call for the Joint Judiciary Committee for June 17th. Senator Case? Present. Senator Cooper? Here. Senator Furphy? Here. Senator Schuler? Here. Representative Chestick? Here. Representative Crago?
Excused.
Representative Haroldson? Here. Representative Jennings? Representative Nemec? Here. Representative Oakley?
Excused.
Representative Provenza?
Here.
Representative Rodriguez-Williams?
Here.
Co-Chairman Landon?
Here.
Chairman Washut?
Here.
You have a quorum, Mr. Chairman.
Mr. Co-Chairman, any introductory comments?
Well, just real quickly, it's good to be back with all of you. I wanted to take a moment, folks, and just thank the co-chairman for playing point guard these last couple of months. He has worked hard to kind of get us ready for this meeting and for the rest of the interim. We've had some things on our plate that have kept me away from being able to devote quite as much time as I would like. And so I just wanted to recognize the co-chairman. He's done a lot of great work and appreciate that, Mr. Chairman. The other thing is just to remind everyone, as a Joint Judiciary Committee, we expect the highest degree of decorum. We're gonna uphold that standard and treat each other well. And I just wanted to remind everybody of that. So, Mr. Chairman, take it away.
All right. Just a heads up for everyone. At lunch today, the committee is going to have a working lunch. We're going to hear a presentation on the Veterans Justice Act. Everyone is welcome to stay. We'll be bringing in lunch for the LSO staff and the committee. There will be hopefully some time afterwards if you need to dash out and get some lunch, or feel free to have somebody bring you some lunch. But we're going to have a working lunch to hear that presentation. So if you want to bug out a little bit early and bring lunch back, that's there. Everybody's welcome. Or if you don't wish to stay for that presentation, you're welcome to depart. All right. Protection orders. Katie?
Mr. Chairman, members of the committee, Katie Adams, LSO. One of the committee's approved interim topics this interim is to study and review issues concerning protection orders. To assist the committee in this review, your materials include a topic summary regarding 3 types of protection orders: domestic violence protection orders, stalking protection orders, and sexual assault protection orders. Your materials also include a copy of the statutes governing these types of protection orders. The Domestic Violence Protection Act, found in Title 35, addresses domestic violence protection orders, and then a separate set of statutes in Title 7 address stalking and sexual assault protection orders. And so what I intend to do is provide a high-level overview of the key provisions of the statutes based on the information found in the table starting on page 11 of the topic summary. And so the Domestic Violence Protection Act authorizes circuit courts to issue orders to protect victims of domestic abuse from further abuse by a household member. In terms of who can file the petition, the victim can file a petition. The petition must be made under oath or accompanied by a sworn affidavit. No filing fees or other court costs or fees can be assessed or charged to the petitioner, and standard petition forms and instructions must be available from the clerk of court. The court may appoint an attorney to assist and advise the petitioner. The court cannot deny relief solely because of a lapse of time between an act of domestic abuse and the filing of a petition. The court can require the respondent to pay costs and fees incurred to bring the action, including reasonable attorney's fees, and remote appearances are authorized. So both temporary orders of protection and permanent orders of protection are authorized. In terms of temporary orders, if it appears from the specific facts shown by the affidavit or by the petition that there is a danger of further domestic abuse, the court shall issue a temporary order. If the court does grant a temporary order, a hearing on the petition must be held within 72 hours after granting the temporary order or as soon as it may be heard. The temporary order, together with the notice of hearing, must be served on the alleged perpetrator immediately. If the court decides not to grant a temporary order, a hearing on the petition must be held within 72 hours after the filing of the petition or as soon as it may be heard. The court must serve a notice to appear upon the parties. In terms of the standard to grant a permanent order, the court must issue a permanent order if the court finds that an act of domestic abuse has occurred. The court must then file, or the order, must be filed with the clerk of court. The clerk of court must send a copy to the county sheriff. The county sheriff must notify the local law enforcement agency in the county where the petitioner resides, and the order must be personally served on the respondent unless the respondent or his attorney was present. There's a statute that governs the effective period for a permanent order, and those orders are effective for a period not to exceed 3 years. The order can be extended repetitively for a period not to exceed 3 years for good cause. There is a tolling provision regarding these protection orders for periods of incarceration or imprisonment, and that extends the expiration date, but not the substantive provisions of the protection order during that period of incarceration or imprisonment. Orders are required to include notice regarding criminal penalties for violation of an order. And so willful violation of a temporary or permanent order is a crime under section 64404, which is a misdemeanor. And they also need to be notified that violation of a temporary or permanent order that amounts to the crime of stalking can result in enhanced felony stalking under 62506E. There is no affirmative defense provision, but no act of the petitioner or the respondent may be construed to waive or nullify any provision of the protection order. There is a confidentiality statute that authorizes the court to issue an order to prohibit the release of the address of the petitioner and any involved children if specified conditions are met. These types of orders are required to be included in a statewide registry for protection orders related to domestic violence. And then there is a statute that addresses emergency assistance by law enforcement officers and provides them limited liability, provided that they act reasonably and in good faith. Moving on to stalking and sexual assault protection orders, many of the statutes are similar, but there are some differences that are highlighted in the table. So these types of orders can be issued by the circuit court. In terms of who can file the petition, there are 3 categories of persons. So we have the victim, the district attorney if the victim consents, or any person with legal authority to act on behalf of the victim if the victim is a minor, vulnerable adult, or any other adult who cannot file the petition. These petitions also must be accompanied or supplemented by a sworn affidavit. No fee can be charged to file the petition or for service of process, and standard petition forms must be available. If the petition is not filed by a district attorney, the court may appoint an attorney to represent an indigent petitioner. There are no express similar provisions regarding lapse of time or requiring the respondent to pay costs and fees, but remote appearance is authorized. In terms of the standard to grant a temporary order, if the court determines from the specific facts shown by the petition and supporting affidavits that there's a clear and present danger of further stalking, sexual assault, or of serious physical adverse consequences to any person, the court may grant and issue a temporary order, but it's not necessarily required to. Upon the filing of a petition, the court must schedule a hearing on the petition to be conducted within 72 hours after the petition is filed. The court must cause each party to be served with an order to appear, a copy of the petition, and a copy of the supporting affidavits. Service must be made on each party at least 24 hours before the hearing, but failure to hold the hearing or complete the hearing within that time does not invalidate any order issued thereon. And if a temporary order is issued, the court must cause a copy of the temporary order to be served on each party. Moving on to the standard for a permanent order, the court must issue a permanent order if, following a hearing, the court finds that conduct constituting stalking or sexual assault has been committed. And then the order must be served on the respondent pursuant to the Wyoming Rules of Civil Procedure. A copy of the order must be filed with the county sheriff. And there are very similar provisions regarding the effective period for a permanent order under the Title VII statutes and regarding continuance of the effective period and tolling for periods of incarceration or imprisonment. These orders must also include notice regarding the criminal penalties for violation. And so under 73510, willful violation of a temporary or permanent order is a misdemeanor. And there are similar enhanced felony penalties for a violation that amounts to the crime of stalking. There is an affirmative defense provision that provides that a request by a victim for the perpetrator to violate a temporary or permanent order is an affirmative defense if the perpetrator is charged with violation of one of these orders. There is a confidentiality provision that applies to situations involving sexual assault. These types of protection orders are not expressly required to be included in the statewide registry of protection orders. And then there are similar provisions in the statutes regarding emergency assistance by law enforcement officers and limited liability for officers. And with that, I would stand for any questions.
Thank you for that excellent piece of work. Questions for Ms. Adams? Representative Provenza.
Thank you, Mr. Chairman. Can you speak to briefly just kind of how this works if someone is coming from out of state that has a protection order and comes into Wyoming, and maybe vice versa, if that's applicable?
Ms. Adams.
Mr. Chairman, Representative Provenza, there are statutes that discuss foreign protection orders. So for the Domestic Violence Protection Act, Section 3521-111 talks about filing and registration of foreign protection orders. So it provides that a petitioner who obtains a valid order of protection in another state, tribe, or territory may file that order by presenting a certified copy of the order to the clerk of court of the district court in the judicial district where the petitioner believes enforcement may be necessary. The filing is without fee or cost, and then the clerk of district court is required to forward a copy of that order to the local sheriff's office and the chief of police for entry into the statewide protection order registry on application of a petitioner seeking enforcement. There are some additional requirements regarding filing. And I'm trying to think if the Title VII statutes have a similar requirement about out of state. But off the top of my head, I'm not quite sure.
Further questions? Representative Harrelson.
Thank you, Mr. Chairman. Just maybe a clarifier. We had an individual in our community that someone brought a stalking claim against, and I know protection and stalking are a little bit different, but kind of fall under the same umbrella. And there's that window, that 72-hour window, and in that time, when this was brought forward, the judge said, hey, you know, we're going to look into this. And part of that was a loss of firearm rights. And that in that 72-hour window before due process in a court happened, there was that loss. Can you speak to that conversation? Because I know that there is that provision from what I can tell, not so much in our statutes, but maybe in our policy that maybe there's a bit of a gray area we need to have a conversation about.
Mr. Chairman, Representative Harrelson, I don't know off the top of my head. I know that these statutes that I've directly looked at, I'm not aware of a statute that directly addresses that, and I don't know off the top of my head. But I think Brian might.
Yep. Mr. Chairman, Representative Harrelson, I'll have to double check. I think that might be a federal law issue more than a state law issue. I'm not immediately aware of, I'll have to double check 68104, but that may be under federal law.
Thank you, Mr. Chairman. Thank you, guys. If we could just have that conversation, because this was something that kind of hit the fan a little bit in our community, and it's something that did cause a little bit of a question to come forward of, obviously, after there's due process in the court, yes, that's a very real conversation that needs to be had, but before that, why is it that we're telling someone who has just had a claim against them, but no proof of that claim being reality, why are they then losing firearm rights? So if we could have that looked into, I'd appreciate it.
Further questions? Thank you. Ms. Butler, you're up. Judge, welcome this morning, both of you. Please state your names for the record and speak to the topic.
Mr. Chairman, members of the committee, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. And I have with me today Judge Brian Christensen from the Natrona County Circuit Court here in the 7th Judicial District. And so I would just say, we appreciate the committee's taking this up as an interim topic. There are some statutory changes that we think would make these kinds of protection orders function better, just procedurally within our circuit courts. And so we have a bit of a list today, Mr. Chairman, but before I start down that list, I just wanted to see if there are any questions for myself or the judge before we kind of step into that area.
Seeing none, please proceed.
Thank you, Mr. Chairman. Starting out just kind of at the top of our list, one of the things that we do have a potential problem with, and that is that 3-day window that we have to serve protection. So we have the ex parte process, which is a victim or a petitioner comes into the court and requests a protection order. So they file their paperwork. The judge will review that paperwork. And within that paperwork, what they're required to do is sign an affidavit. And that affidavit under oath stating what is the basis for the protection order. And that is within all 3 kinds of protection orders. So domestic violence, sexual assault, and stalking. The judge then reviews the affidavit and the filings and then determines whether or not there is a basis to issue an ex parte protection order. So that is that 3-day window. That is that ex parte protection order that allows for a protection order to go into effect for 3 days. And then the court is required to set a hearing and provide notice to the respondent in order to fully vet and allow the respondent to respond to the allegations that were made in the affidavit. And then at that point, what happens is the judge will make a determination on whether or not a more permanent protection order should go into place. And that can be for up to 3 years at a time, as Ms. Adams explained. And so one of the things that we have a really difficult time with in our circuit courts, and Judge Christensen can speak to this, and I can tell you we hear it from our clerks quite often, is service within 3 days is really, really, really difficult. And so what will happen is when they get the first petition, the clerk will set the hearing within 3 days, and not inevitably, but very, very often that 3-day window lapses and they'll have to reset the hearing, and then they'll have to reset the hearing, and then they'll have to reset the hearing. And often that is because the respondent cannot be served or found. And so one of the questions, or I guess one of the things for this body to consider is whether or not that 3-day window is functioning appropriately and whether or not that should be extended for a certain period of time to allow for service upon the respondent. And again, just quite often that 3-day window is just not enough.
Representative Provenza.
Thank you, Mr. Chairman. Ms. Butler, do you have any idea how many times they have to reset that 3-day clock generally? Like, should we look at a 10-day window, or any recommendation on that would be helpful?
Judge.
I'll turn on my mic. Thank you, Mr. Chairman, and Representative Provenza. It depends on all kinds of factors. is the person able to be found or not? Sometimes I'm amazed, I'll walk into court and the people are served within 3 days. So, and it happens more often than not. But the problem is where we can't find the individual, where the individual lives out of county, out of state. 3 days is, especially out of county and out of state, it's a meaningless exercise, wastes everybody's time. Trying to get somebody served within 3 days in that fashion. I think we've had discussions on expanding that to 10 or 14 days, being realistic to have those set. And it depends on your community, how quickly they can get somebody served, how quickly they can be found.
Thank you, Judge. And then if, in those cases where you mentioned someone's out of state and it's much more difficult to find someone, what happens when you can't find them? What's that process?
Mr. Chairman and Representative Provenza, it sits out there and it's not enforceable until they're actually served. So there's not, the question about gun rights or any other provision that might be in an ex parte is not enforceable till somebody actually has notice of it. We have problems with some states requiring a service fee before they'll even serve it. We're trying to attempt to look into the federal laws on that to see if that's appropriate, but some states will accept it and go serve them immediately. We've got great luck with Colorado, not so much with Texas. And so once they are served and with the advent, the technology these days, people can get on video access with us in court. They don't have to be up here in 3 days like it used to be a few years ago. It's like they've been served, now what? Can they call in? Is it really them? Am I swearing you in? Can't see your hand if you're swearing in. But so the technology has helped a lot in that area. But it's always an issue.
So Judge, if the ex parte order is not enforceable until service, what's the purpose of the ex parte order? Is it just anticipatory that when service occurs, then it becomes applicable?
Yes, Mr. Chairman, once it's served, then it is enforceable as a violation of statute criminal law, because you are put on notice so that at that point, you would have an enforceable order.
Mr. Co-Chairman?
So Judge Christensen, thanks for being here. Lisa, thank you too. I think this might be a question for the judge. So if we were to ponder looking at that 72 hours, in the back of my mind, I'm thinking, is there a risk that we're going to slow this process down even more than it already? I've been around victims having served my years at the college, all those years, so many situations like this. I worry that we're requiring so much out of the victim, and then we extend this time period. What's your thoughts on that? Are we running a risk of slowing this thing down even further?
Mr. Chairman, Mr. Chairman and Chairman Landon, if the ex parte is served, it has full effect just like if you had the hearing. So if the hearing, it grants the continuation of the ex parte. We have had, for example, say, come in on a hearing for 3 days, the respondent has an attorney or wants to attempt to get an attorney, will continue the ex parte order and it's still in force and effect until the next hearing. So you can have an ex parte order that's just like a permanent order that's out there with full force and effect by law enforcement and the criminal statutes until you actually have the permanent hearing, which can extend it permanently for up to 3 years. So if you have the ex parte out there, you've got an order if it's been served. So.
Please continue.
Mr. Chairman, the next item on the list pertains specifically to domestic violence protection orders. And so one of the things that you will find in this stalking and sexual assault protection orders is if the minor is a victim, there are statutory, it's laid out explicitly who can petition on behalf of the minor. And that is not that case is not true in the Domestic Violence Protection Act. And so it doesn't explicitly lay out in that statutory framework who can petition on behalf of a minor when there is a Domestic Violence Protection Act, or when somebody is petitioning for a domestic violence protection order. And so again, this is just something that has created some confusion amongst our circuit courts, and something that if those two pieces of legislation were mirrored, that language, that would clear up a lot of confusion that has occurred within the circuit courts.
Ms. Butler, have you submitted these in writing to the LSO?
Mr. Chairman, we have not. I think this was, our intent was to bring these to your attention, and then if you so choose, we can work with LSO for the next interim meeting to come up with some language.
Very good. Anything further? Judge, anything?
Nothing more on that one, Mr. Chairman. We do have more. The next item is the service of extensions on protection orders. So as you heard from Ms. Adams, protection orders can be effective for up to 3 years, but they can also be extended beyond that if the petitioner shows that is warranted. And so again, service becomes an issue here, and Judge Christensen can speak to this better than I, but one of the things that I think the courts struggle with is finding those respondents again when that protection order is extended. In accordance with the initial order, the respondent and the petitioner are required to keep the court up to date on their residences where they live. That does not happen very often. And so what will happen is the judge may issue an extension of that protection order, and then service becomes really difficult because we do not know where that respondent went. And so different methods of service, aside from, the sheriff going to somebody's home and serving that person, would be helpful by certified mail or mailing to the last known address that the respondent is required to keep on file with the court. Both of those could be potential options and would be helpful in terms of making sure that the respondent gets served with the paperwork in the manner that's required by law.
Mr. Co-Chairman.
So, Mr. Chairman, thank you. Lisa, that just seems to make sense. I mean, I don't understand why you wouldn't want to lean toward the victim on something like this and just provide, if you can't find that individual, that seems like a pretty easy fix in statute. But how prevalent is that? Looking at Judge Christensen, do you run into that a lot where you can't find these guys?
Mr. Chairman Landon, quite significantly. A majority of the cases, they've moved within 3 years. And getting them to require for that to be enforceable, it needs to be reserved on them in some manner. We do have some rules that allow for email and mailing to last known address, which I think would help out a lot on that. If we knew that could, if they're informed on the petition that they are informed that this can be continued for good cause, and after the 3 years modified, continued. And so they're put on notice of that. But how do you get them notice that it was actually done? And if you have a avenue that just allows for the email address or the mailing to last known address as service, then that would suffice for that. But otherwise, we're not getting them actually served in some situations.
Representative Provenza.
Thank you, Mr. Chairman. Judge, do you know if others, how other states handle this in terms of, is this something that other folks are doing? Part of my concern, I guess, would be, respondent then violates protection order after it's been sent through mail, and can say, well, I didn't know. And so is there issue with being able to basically apply the law on the back end of it.
Mr. Chairman, Representative Provenza, it's the same for a protection order. If you serve them and they don't show up for the hearing, they're deemed to be put on notice that that order has been entered. So as to that being able to be extended, it's up to them to know that order's been terminated or lapsed. Other states, I wondered about this, decades ago when this first happened, and they went to lifetime protection orders, and I wondered about that, and I was like, now I kind of know why. Because you can petition to have those terminated if you are a respondent earlier. A lot of times we see the petitioner even respond, file a request to have them terminated. So it's easier to do it that way than so I was wondering about why those states did that, and I'm thinking this is the issue.
Follow up?
So then would your recommendation ultimately be then that maybe we move towards that system, or is it preferred by the courts that we just extend that? Because that also makes sense to me, that maybe we can take out some of the costs that are accrued by the state by not having to chase people down. If we can, if as long as there's a path forward to revoke that, if it makes sense.
Yeah.
Judge?
Mr. Chairman, Representative Provenza, I can't speak for the whole branch on that or an opinion on that. I really don't have we'll work with whatever we're given. So.
Anything further?
Mr. Chairman, we do have further things. The next one is just to, again, I think, marry up some of the language in Title VII and Title 35. So Title VII is where we have the stalking and sexual assault protection orders. Title 35 is where we have our domestic violence protection order language. And what you'll find in Title VII under the definition of court, and this is where the protection order can be brought. So if you're petitioning for a protection order, the definition of court within Title VII is the county where an alleged victim of stalking or sexual assault resides, or where the alleged perpetrator of the stalking or sexual assault is found. That is different than in Title 35. So Title 35, which is where family violence or domestic violence protection orders are found, is the county where an alleged victim of domestic abuse resides or is found. So there's no language in there about where the alleged perpetrator is found. And so the circuit courts are limited in basically their jurisdictions and what kind of protection orders they can hear based on the residence in domestic violence protection orders, based on the residence or where the victim can be found, but not where the perpetrator can be found. It may also, and I'll let Judge Christensen speak to some of the difficulties that this poses, but also just where either the alleged victim or the alleged perpetrator reside or can be found. Maybe it would expand the ability for circuit courts to be able to issue those protection orders when people come into their courts.
Judge?
Mr. Chairman, to add on to that, it's not uncommon for our petitioner to leave the county, go where they may have resided before, go live with a sister or family in another state, and they're not residing here no longer or are found. And so, but the action happened here and the respondents found here, the incident here. And I would go farther to also put the phrase, or where an act or incident of stalking or sexual assault occurred, or where an act or incident of domestic abuse occurred. As we do in our small claims, allowing where the incident occurred to be filed. You can have a situation where an incident happened here. They're here for let's say the rodeo this week, and a domestic violence incident occurs in a hotel and they both leave, but he's charged with a criminal offense and gets convicted of that, but you can't file the protection order here because neither one of them are found, even though the incident's here and you have a criminal charge that would oversee that. Would be res judicata, you got the conviction and you can get a protection order with that. The other state where they reside may not allow it because the incident didn't occur there. So there's different states have different definitions on this. The other issue is if we don't have that in there, it gets reviewed for, do we have a minimal contact standard? Does that individual have enough contact with the state of Wyoming to actually be a respondent or defendant in a case here in Wyoming? And those have been taken up into our for appellate review and found sometimes that they do not. So if they reside in Texas and minimal contacts here, though the incident may have occurred here and our petitioner may be found here, we're not able to go forward on that case. But if we have the statute like in small claims where the act or incident of domestic abuse occurred, that would hopefully solve that issue.
Please continue.
Mr. Chairman, just a couple of more. The next one is something that Ms. Adams mentioned when she was doing the initial presentation, and that is that the court can, according to statute, appoint an attorney to represent a petitioner when a case is filed. I can tell you there is no mechanism for this to happen, and there is no money for this to happen. So it allows the court to do this, but there's no funding, right? So it's not like when you require, in some instances, the GAL's office, right? When you appoint a GAL, there's a pot of funds to pay for that GAL, whether it's state funds or something else. In this instance, there's no mechanism to allow for that. So if a judge appoints a private attorney to represent a petitioner in a case, we cannot pay them because we don't have a budget to do that. And so essentially that appointment of an attorney, basically that provision within the statute basically gives, I think, the petitioners a bit of false hope that they will be able to get an attorney or the court will appoint an attorney when that, I think, and I'll let Judge Christensen speak to this, but I don't think it happens all that often. And so that's something that I think we would like for this committee to take a look at, because it does create a bit of a conundrum for circuit court judges when they can't appoint an attorney, but there's no mechanism to actually do that.
And Mr. Chairman, we do refer to the Protection Coalition, the legal aid, but that is based on resource availability. And some counties know that you're not going to find those attorneys in those counties. Depends on our county, how busy they are, if they're able to take those cases or not. And these things, as Chairman Landon said, are time sensitive and they can move pretty fast. And if you can't get an attorney in there, you're not going to get one. There's no mechanism, as stated by Ms. Butler, for appointment of an attorney and a budget to pay for them. It does allow in the statute for the respondent to pay for an attorney. Again, haven't seen too often an attorney step in and say, I'll do this, and then I want the respondent to pay. There's no enforcement for that to happen. Part of the problem is with these orders that are consequential, that the issues, the conditions on them for child support, for anything, well, that'll come up later, but we have no enforcement on those. It has to be brought by the county attorney for a potential, if it's, you're looking at a jail sanction, you bring them in and wave your finger at them and say, you're supposed to follow this condition. It's not much you can do if they're not in violation of contact, which would then be enforceable as a violation of the protection order under criminal statutes.
Representative Shostak.
Thank you, Mr. Chairman. Have the courts ever referred victims to the DV clinic at the College of Law?
Judge?
Mr. Chairman, Representative Chestic, I'm not sure. From counties outside of Albany County, I'm not sure that happens. In Albany County, might happen.
I believe the clinic, like most of our clinics, do serve statewide. We do have a budget, and a lot of our volunteers travel, and we do serve counties well beyond Albany County. So might be something you want to look into.
Ms. Butler.
Mr. Chairman, I think the final one, although maybe I'm missing one, and that is, and I think this is more of a discussion topic because quite frankly, I'm not sure, and I know we've talked a lot with the judges about this, and I'm not sure what the solution is, but that is the statute that allows for tolling of protection orders. And so in the memo that Ms. Adams provided to you, there's some language in the statutes that allows for protection orders to toll, basically stop for a period of time while the respondent is imprisoned, so in jail or in the state pen. And then what happens is when that person, that respondent is released from imprisonment, then that amount of time that it was told is tacked on to that protection order. This is a really difficult thing to implement. And that is because our judges, our law enforcement officials who are called when, the respondent comes to the petitioner's house and there's a protection order in place, they don't know that that protection order has tolled. They have no notice. The tolling is automatic in accordance with the language of the statute. And so when somebody is in jail for 2 weeks and, the petitioner may know, but nobody else knows, the court doesn't know, law enforcement doesn't know, that protection order that the petitioner is using has not been updated to reflect that tolling. If law enforcement gets called after it says that protection order has expired, but it hasn't actually expired because of the tolling, it creates a whole lot of confusion around how that should be implemented. And so it has become a really difficult thing for our judges, and I don't want to speak on behalf of law enforcement, but I would imagine for our law enforcement officials as well, just because law enforcement sees the expiration of the protection order, which may or may not have been told, and they don't have an updated protection order. And the judges are not alerted about that tolling timeframe. So they are not, they're not moving forward with updating the protection order with a new expiration date. So I think we bring this more as a point of discussion, just to bring it to your attention that it's a difficult thing, and I don't know that we know what the solution is, but it is something that's really hard to implement.
Just a quick question. If we went with a lifetime protection order with a process for ending it at some point, would that allow us to do away with the tolling?
Yes, Mr. Chairman, that would be one of the benefits of going to that lifetime as well.
Mr. Co-Chair.
Thank you, Mr. Chairman. At least I want to come back to this notion of not being able to appoint an attorney. It doesn't seem to me like that would be such a big line item. Do you have any guesses as to how many of these kind of cases we're looking at, where it seems here you've got a victim, normally it's a she probably has some kids at home, she doesn't have control over the budget, more than likely. It just seems like the right thing to do in the statutes to make it feasible for you to appoint somebody. Judge Christensen, can you talk to us a little bit about that? I mean, how many of these are we looking at, Judge?
Mr. Chairman, Chairman Landon, it's not an original idea. We brought this up with when Senator Perkins was chairman of this committee years ago. We tried to do a line item in the Protection Coalition for appointment of an attorneys. They do have attorneys available. Again, it's a staffing and resource thing, but we weren't able to work that out years ago, and that was a solution I had many years ago to try and do that, to get a budget in there for appointment of an attorney, and then finding out who those attorneys would be or available to take those cases is the next issue.
Ms. Butler.
Mr. Chairman and Mr. Co-Chairman, we could pull some data. I mean, we couldn't pull data on how many cases would need an attorney appointment, but we can pull some data on how many protection order cases we have had, over the last 5 years, and that could give you at least a starting point. I think Judge Christensen hit on a few of the potential problems, and that is one of the things that we run into pretty frequently now with statutes that allow us to appoint attorneys is how much they're being paid, right? So if it's a private attorney, 9 times out of 10, they're going to make much more money by not taking that case and taking another kind of case. It doesn't mean that they won't, they often will, but they will earn more money in another way. And then the second one is we are in an attorney desert, as you all know. We are in a legal desert, and finding attorneys to do private cases is difficult. And so appointing attorneys to do these kinds of cases could also be difficult. I think, if that's something that this committee wants to pursue and look into, we'd be happy to help in whatever way that looks for you all. And if it's working with the coalition, we could do that, or working with another entity.
Mr. Co-Chairman.
So, Mr. Chairman, it sure seems to me like, and members of the committee, that we would want to at least look at that. You could construct the statutory language to say that you have to exhaust all other avenues, and if that's the case, at least we would have a fallback for our judges to be able to, to appoint an attorney. It seems like that's worth the conversation going forward. You don't want a victim out there not able to get representation is the point. So.
Mr. Chairman Landon, if I could add on to that, one of the avenues also to look at that's not addressed in the statute is child victims and sexual assault protection orders. We have these petitions filed by a parent. They come with no attorney, and the respondent may show up with their defense attorney. We do everything we can to get them an attorney, get them over to the DA's office. I think a quick fix on that would be to allow, if a petition's filed on behalf of a minor victim, the court may appoint the county attorney to represent a pro se minor victim. It does allow for the DA now to file, it refers to if a petition is not filed by the district attorney, but it doesn't say specifically allowing the courts to appoint the district attorney. And those situations are probably the most concerning, and especially where a criminal charge is contemplated or may already be filed.
Thank you. Anything further, Ms. Butler?
Mr. Chairman, I don't think so, unless Judge Christensen has additional items.
There are several items, but Mr. Chairman, the other one is the legislature has us reviewing almost like a mini divorce case in these domestic violence cases, where we are determining custody, support, visitation. We issue those orders, and child support enforcement does not enforce our findings for court-ordered child support. And so that's an issue. Violation of those orders, really, we try to address them when they're brought to us for order show causes. But again, it's up to the district court at some point to make those permanent. They override any order we do in a temporary, either an ex parte or in a permanent order of protection. The district court ultimately has a say over what happens on the child support enforcement and visitation, but it can take several months to get before a district court judge sometimes, and those enforcements are you're hoping for the best.
Very good. Thank you both for your testimony, Mr. Co-Chairman.
So, Mr. Chairman, just real quickly, I wondered if we could get maybe a comment from Judge Christensen. In your packet, you have Senate File 75 from a couple of years ago, and Judge, you and I worked together on that a little bit. That particular bill went out of the Senate, I think 30-0, and just ran into some struggles over on the House side. But just for the purposes of knowing what that bill contained, can you speak to that stipulation order that and Remember, some of our judges really thought that would be a good idea to have in our statutes.
Yeah, Mr. Chairman, Chairman Landon, that had specifically had to do with the district court ruling in Sweetwater County. It was a stipulation, a finding that a stalking had occurred for enforcement of an enhanced felony stalking aggravator. And so it was found that a stipulation was not, because there was no finding of that, that a stalking had occurred. That potential bill, or if it's filed a bill, would address that issue specifically to allow for a second offense or a violation of a stalking order being enhanced to a felony stalking upon a re-incident by the respondent or perpetrator.
So thank you, Judge. And Mr. Chairman, just for the information of the committee, it's possible that that the representative from Sweetwater County and I would bring that bill back, whether or not it would be folded into anything the committee would want to do with respect to the protective orders. We could certainly do that too. I'm not advocating either way. That was actually the representative is the one who suggested some amendments that really made it where the bill wouldn't work. And he's come back to me to indicate that we maybe ought to run it again. So just wanted to let you all know that, and we may run that one back up the flagpole. It seems to have some merit. So thank you, Mr. Chairman, for that.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Butler, Your Honor, I've been made aware of a situation where there might be a potential loophole when it comes to appealing the issuance of domestic violence or stalking orders. So some states have closed that loophole by stating clearly in statute that during the pendency of an appeal, the underlying protection order in the original court stays in full force and effect, because a lot of times an appeal can take longer than 6 months. And I don't really want to elaborate too much on the situation, but just wondering if either one of you feel the need for closing that loophole, or if you've encountered situations where that would help.
Judge?
Mr. Chairman, Representative Rodriguez-Williams, and beyond that, it's also if you've got that protection order and then one of the parties wants a modification while it's on appeal. It's not unheard of. And before we got into scanning all our papers in our files, the file would go to district court. We'd have a request for a modification, and we would have no clue what was in that file, and we couldn't get back from the district court because it was up on appeal. Now we can recreate the file with the scanning, and we do that. So there's still action going on in those cases, even when it's on appeal. Anything that would address that the order is still in effect, especially you can see where if the order terminated while the appeal was up, it may be found to be moot. It may be found that they filed a motion or didn't file a motion to continue for another 3 years for whatever basis they presented to the court. So you would have some issues sitting there that could happen while the thing's on appeal. And so it would help clarify that.
Okay, good. Thank you both very much. I think I see Mr. Thompson in the back of the room. Maybe there's some law enforcement things here that we want to touch on the protection orders. I just wanted to afford you an opportunity to tell us a little bit about how this works on the law enforcement side. We heard some testimony about a registry that's only required for one type of protection order, but not necessarily required for the others, whether that registry or lack of registry has an impact on your abilities. And the ability to locate folks for service and those sorts of things. But anything you'd like us to hear about protection orders from the law enforcement vantage point, please share.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, which is the Wyoming Association of Sheriffs and Chiefs of Police. I hadn't prepared to testify on this topic this morning, so I haven't polled our members specifically. But just in the discussion that we've seen in the last 20 minutes or so, I want to mention that tolling concern. That is something that we've been discussing amongst the sheriffs across the state for the last year, trying to figure out how we can track those additions to a protection order. And really, it comes on a case-by-case basis. If someone is arrested and serves some time in a county jail where that protection order is in place, and it's a lower population where you have a small number of protection orders, it's kind of easy to connect the dots there and do that. I'm not aware of any database that gives us in law enforcement access to that extension. I was trying to inquire already if there's a automatic setup through the dispatch centers that is there do they look at the Supreme Court, or is that local when they run a protection order through the CJIS system? And in my experience, we have those entered on the local level with a start date and an end date and expiration on them. I'm not aware of a way for that to get extended in that system. And on top of that, if someone is serving a jail sentence in another county, we have a very nomadic population in Wyoming. It's very common for someone to be, arrested and serve time in another county, and local law enforcement in their home county never even knows about that. So I was thinking of that from an application standpoint. A fair and equitable application of that current law of tolling is very difficult. I would say that oftentimes an officer involved in some sort of issue with people subject to a protection order would just notice that it was expired and never dig deeper into it to see if there was any extension to that. And I was just thinking that the only way to track that is another central database, which would then require more reporting from jails. I mean, how often do we really have tolling occurring with our protection orders across the state, I think, is the biggest question before deciding on is this something we should move forward on tracking statewide. But just another database for us to search in is also a difficult issue for us. And then there was some discussion about the service of protection orders. So your sheriffs across the state and their deputies are tasked with that paper service, that process service of protection orders. And while I would say that most of the people that are subject to that service are cooperative and work with law enforcement to accept service of those, there is a percentage of them that are very difficult to find. On purpose oftentimes, and even on accident. If they've moved, people don't update their driver's license addresses until they're renewed. People don't call the local sheriff's office or police department to update their address with them if they've moved. So there's really not a way for law enforcement to get good access to a new address for someone unless they've had encounters with law enforcement. We've had the discussion locally when I was sheriff about ways that we can provide service through emailing, through electronic means. And, I don't know that we've come to a consensus on what that looks like. It hasn't been a discussion from our membership in general. This would, of course, be a sheriff focus because they're tasked with that process service. But I can't imagine any of the sheriffs being opposed to an electronic service option. And what specific ways would that be allowed? I think the seriousness of a protection order and all the other things that are encountered with being served ex parte and then a protection order and some of the loss of rights that we were discussing earlier would make, mailing or emailing that to them if they didn't receive a copy of it, that's pretty serious allegations to violate if they weren't really provided with a copy of it. But having a mechanism for that email option and acceptance of that email service would be something I think our sheriffs would be very interested in.
Sure. Mr. Thompson, are you at all aware of people losing their firearms right during the ex parte period? Is that something that's commonly ordered in these protection orders? They lose their firearms rights?
Mr. Chairman, I've been out of actual law enforcement for a couple of years, but my memory would indicate that that was part of the ex parte. When I was serving ex partes, there would be I want to say it was like a 72-hour window before they would have the opportunity to be in court. It's a short time period, but I didn't research those statutes prior to today, Mr. Chairman.
Mr. Co-Chairman?
Mr. Chairman, thank you. Mr. Thompson, I want to go to the issue of just communication in general. It's a little bit concerning to me that that one of the perpetrators of a domestic violence enough to get himself or herself thrown in jail for a while. I wonder how the communication works in that circumstance. Is it pretty informal at this time, or it seems like a communication database that would go out across to our sheriffs, for example, to say, by the way, so-and-so has been released. Do we even know that? I mean, do other sheriffs know it? For example, if we had a bad actor here in Natrona and he's getting out and he's going to go somewhere else, it just seems like better communication would really help keep an eye on things. You don't know where the victim is at this point. It just feels like you could see a lot of things flying under the radar, and some of these are pretty egregious situations. So how does it work now?
Mr. Thompson?
Yeah, Mr. Chairman, to answer the good co-chairman's question there, it varies, and I would say would be a lot easier in smaller populations. If every sheriff's office and police department in the state received a notification when every misdemeanor or felon released from jail pursuant to some domestic violence charges was released, we would be inundated with communication and not be able to track it. And the majority of the time, we're not going to have contact in Niobrara County with a person from Albany County or Lincoln County ever. So having that accessibility to that system would be something, but as far as affirmative notification would be too much, I think. But just having access to that could be helpful, but it's already within their criminal history. So if we run into someone in, say somebody that was arrested in Sweetwater County and last week they got out, and then they had an encounter in Niobrara County and that officer ran a criminal history on them, it would show that arrest and the day they were incarcerated and the day they were released, and that the outcome was pending, that there might not be a conviction yet, or if there was a conviction, it would have that in there also. So.
Just not to belabor, but just to really hone in on the victim, for example. It just seems to me like if we had a really egregious act that occurred and it ran through the court system and somebody ended up in prison for a time, and that person gets out, it would feel more comfortable to me to know that at least the local law enforcement folks would be aware of that, and maybe in the briefing that next morning, hey, somebody might want to run by so-and-so's house, just make sure that we're okay. Does that occur now? I'm just trying to get a sense for how much communication we do have.
Mr. Thompson?
Mr. Chairman, to answer that question, when you're talking about someone released from the prison system, there's a very robust communication in Wyoming of people being released from the prison system and where they're going to, whether they're released and done, whether they're on probation, and it shows their home of record and where they're being released to. So that information, to my understanding, goes to every officer in the state, should they choose to look at the attachments on that monthly, bi-monthly email from the Department of Corrections. And additionally, we have victim services programs across the state. They look a little bit different. Some are housed in law enforcement entities, some are housed in county attorneys, some are standalone like a nonprofit. And I think there's other people in the room that can testify to the efficacy of that, but I think that they do a great job of notifying the victim in those instances that you're mentioning.
Okay, thank you. Mr. Representative Cheswick.
Thank you, Mr. Chairman. Mr. Thompson, I'm curious about, you mentioned a database that apparently when a permanent protection order is issued, somebody, and that's the nature of the question, somebody enters into a database someplace, the beginning date, the end date. I'm curious about where that database is. Is that a local database? Is that maintained by the clerk of district courts? Is it a statewide database? Who does the data entry? Tell me a little bit more about that database, and then we can explore how to update that to make it better for the tolling situation. But go ahead.
Mr. Chairman, to answer that question, there is a very robust database for tracking those protection orders that are in effect. In my understanding, we enter them locally through our dispatch centers into the criminal justice information system, whatever term you want to call it, NCIC, Wyoming warrants, all of those programs that we use to help law enforcement communicate whether people are wanted or subject to a protection order. So once that protection order is in place, say it happened in Sheridan County, and the respondent and the petitioner are both in Sheridan County, and there's a protection order that's in place. If one of those parties runs into law enforcement in South Texas, and law enforcement checks their name through the database, they'll be notified that a protection order exists and who the protected person is. So that if they see them in a car in South Texas, it could be a violation of that protection order if they're together and warrant further investigation. And to my knowledge, every state has reciprocal laws to have the ability to enforce a Wyoming protection order in their state. Wyoming does enforce out-of-state protection orders in Wyoming.
Follow-up. So the data entry is done by a law enforcement. It's not a clerk of court. It's a law enforcement officers making the entry to say this order is in place. Is that correct?
Mr. Chairman, I believe so.
Okay. The problem is, I'm just trying to identify where the problem is, where the breakdown is. And the breakdown apparently is if somebody is incarcerated and then the protection order is told, we then have a problem on the back end when the database says the order is expired, but the law says it's not expired because of the tolling period. If the original data entry was a law enforcement officer, does that law enforcement officer ever have any way of finding out about that tolling period? Or how do we make sure that the tolling period gets added into the database? Can you think of a way to do that?
Mr. Chairman, I think I'm the wrong person to answer that question.
Fair enough answer.
Yeah, yes, sorry.
I sense Ms. Chambers over there is eager to come to the microphone. Thank you for.
Thank you, Mr. Chairman.
Mr. Chairman.
So we have exhausted our time allocated for this topic, so we need to keep moving. But Mr. Fuller?
Yeah, Mr. Chairman, I was just going to address a couple of the questions. First, 3521.110 speaks to that registry. Subsection C requires the clerk to forward the order to the local sheriff or chief of police, who then must promptly enter that order in the system. Subsection D says that system shall be accessible to, among others, law enforcement. Nothing in that section, though, Mr. Chairman, talks about the tolling. So that is not covered in that section. And then, Mr. Chairman, back to the question regarding firearms rights. So under the Gun Control Act of 1968, this is federal law, 18 U.S.C. 922 G8, that subsection provides that a person who is subject to a court order of protection is prohibited from possessing firearms. There are requirements associated with that protection order, though, that before that federal law is triggered. So first, the order must have been issued after a hearing of which the person received actual notice and the person had an opportunity to participate. The order must restrain that person from harassing, stalking, or threatening an intimate partner of that person or a child of that intimate partner, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child. And then third, the order must include a finding that the person represents a credible threat to the physical safety of that intimate partner or child, or by its terms, the order explicitly prohibits the use, attempted use, or threatened use of physical force against the intimate partner and child that would reasonably be expected to cause bodily injury. And Mr. Chairman, I would note that that specific provision is currently under challenge. It is before the United States Supreme Court. The case is United States versus Rahimi. I think there would be, I assume there would be a decision on the constitutionality of that provision within the next 2 weeks.
Very good. Thank you for that. Representative Harrelson.
Thank you, Mr. Chairman. Thanks for that clarification. I am going to throw some more dirt in the water, though. So in this situation, it was a handyman that was working on a landlord's house, and the neighbor who had a beef with the landlord saw this guy and thought, this is a way we can get even. And so they said, well, this person's stalking because they come every single day at the same time when my daughter's going to school. Well, the guy's replacing the windows in the house. And so it's a situation like, it had nothing to do with a relationship. It was completely off basis of that. And so I question, as these ex partes are being released and we're removing someone's firearm rights, I don't even think we're aligning with what you just read. I think we're maybe even going a step further and maybe opening ourselves up in a way to being in a breach, and probably need to have a conversation in that realm, because I can definitely understand there may be, obviously there's so many situations we could find ourselves in, and that is the hardest part about this. But like in this situation, it was very much, once it hit the court was like, oh, there's nothing here. Why did this even get to this point? But I have a constituent who lost his firearm rights for 72 hours because of it, and had to get a lawyer and had to do all of these things. So I guess I'm going to throw that out there, that maybe our ex parte might even go beyond what that federal law states, and I have to ask the question, why?
Okay. Just a reminder, this is our first meeting on this topic. We'll probably take it back up in September, so there'll be more robust answers. So succinctly.
Thank you. Kara Chambers, Division of Victim Services, Wyoming Attorney General's Office. Thank you. The Rahimi case was what I was going to mention. The second thing I wanted to talk about, just perhaps for your second meeting, the funding for attorneys. Currently, my division passes through VOCA, which is Victims of Crime Act federal funds, to Equal Justice Wyoming, which is part of the Supreme Court. And they pass that through to the Wyoming Coalition Against Domestic Violence and Sexual Assault to fund attorneys. So should you like to add money to that fund, there is a mechanism to do so. And I would encourage you to perhaps invite the Executive Director, Angie Dorsch, with Equal Justice Wyoming, to perhaps attend the next meeting, should you want to pursue that topic. The other thing I just wanted to clarify on victim notification as it relates to tolling. There is a robust system also funded through our office. It's called the VINE. It's the Victim Information and Notification Everyday System. And it is linked with all 5 of the correctional facilities and I believe 22 of the 23 county jails, and it's connected to their booking system. Victims utilize that robustly to get notification of any change in custody status with an offender, whether it's being transferred from jail to prison, being paroled or released. And so victims, because that is a federal law, get that sort of notification. It's not uncommon for a probation officer to register against that. And so there is a mechanism that already taps into these booking systems to let people know when an offender is being released. Victims can register against these offenders. This is a nationwide system. Again, the VINE system is housed within our office and again, covers almost all of our correctional facilities.
Just let me ask a quick question on that. So let's say we have somebody subject to a protection order. He's visiting another county. He gets arrested for DUI. He spends 3 days in the local jail, and then he's released. Nobody in that county is thinking domestic violence. They're not aware of that. How's that handled? How's that communicated?
Chairman Washington, well, the victim knows. And typically, for the Vine system to work as it currently is, the victim
But in
registers.
terms of tolling,
So what happens?
victim may know, but
Right,
the rest
right.
of the system.
This is what happens right now, and why it's not a perfect system, is the victim is the one who knows. And the victims are the ones who are going to the court to petition to get the tolling acknowledged, which I would argue is not an ideal system. A lot of heavy lifting is on these victims in these cases, because they know when their offender is incarcerated and when that person hits the streets, because they have to stay safe.
Anything further?
No, that is all. Thank you, sir.
Questions, Ms. Chambers, Representative Chestic?
Thank you, Mr. Chairman. Ms. Chambers, so the Vine system is not the same system, not the same database we were talking about with law enforcement. It's would a solution be to have those two systems somehow connect with each other and exchange data so that they could, when you update the Vine system, it updates the law enforcement system? Is that a possible solution?
Ms. Chambers?
Chairman Washington, Representative Chestic, there is another function that we don't currently have that specifically connects those two. We will have DCI and the Deputy Director for the CJIS system here later today and tomorrow, and we could get into that, but they are two different systems. You're talking about the CJIS, the Criminal Justice Information System that receives information from NCIC and the courts, is different than the Vine, because that is just linking up to jail and prison booking systems. But there is a, of course, with the price, there is a model out there, Vine PO.
Very good. Anyone else in the room wishing to testify in public comment about protection orders? Anybody online? Okay, I'm going to close public comment. Committee, if there's a desire for a bill draft or to continue the topic for further discussion in September, there will be a requirement for a motion and a majority vote of the committee for a bill draft. So discussion from the committee. Your preference, Representative Chestic?
I'm not going to suggest a bill draft at this point. I do want to keep this on the agenda for, it sounds like there may be some administrative things that could be done to have the two different systems work together, and I don't know if we need any legislative intervention to make that happen, but I'd like to hear back in the next meeting as to whether the problem can be solved administratively and we don't need to do anything. I'd like to know that. So just keep it on the agenda.
Very good. Senator Case.
Thank you, Mr. Chairman. At some point, I'd like a little bit more discussion of what the tolling aspect means and how that's important. I've been trying to get my hands around that because as I understand tolling, to look it up, is that it suspends the protection order for the time that the person is incarcerated so that it can come back in automatically when the person is released. Makes a lot of sense in some ways because when they're released, there's may not be time to go get a court date and redo all that again, and they could be a danger. But there's that side of it. But the other side is it's sort of a, if a protection order originally had a 3-year deal and now it's 10 years later, what is the significance of that? And is that, if we're going to address this, I'd like more discussion about that because we didn't even talk about that part.
Mr. Co-Chair.
So, Mr. Chairman, I really appreciated those comments because I don't know enough about that either, and I'd like to learn more. But I was compelled by some of the things that were brought forth by one of our good judges and by the administration. There were 4 or 5 bullet points that I think are worthy of our going forward with, whether we do that in bill form or not. It feels like these protective orders deserve some amendment considerations. And so whether we execute that draft now, Mr. Chairman, or we wait till September and then take it up in November, I would suggest that maybe we get started with a bill draft which would include at least 5 of the bullet points makes it pretty easy for us to have a policy discussion. We can extricate whatever we don't want in the bill or whatever as we move it forward. But I guess I would lean toward wondering why we wouldn't want a bill draft now that we could take up in September. Doesn't have to include the tolling piece, but it could, who can file the service of the extension, the court appointment piece. There were several points there, Mr. Chairman, so maybe a little more discussion. I don't.
Thank you, Rick. So those are the 5 bullet points from Ms. Butler's testimony, is that right? So is that a motion for a bill draft? Do we have a second? Second. Second by Senator Schuler. Discussion on the motion? Everybody clear on what the motion is? We're just going to ask a bill draft based upon the 5 bullet points of Ms. Butler's testimony. Representative Provenza?
Thank you, Mr. Chairman. Yes, I just want to make sure we're clear. One bill draft with, and this would include the 3-day window to serve protection ex parte process, changing that to how many days, who can petition on behalf of the minor when asking for domestic violence protection orders, and they'd like mirrored language for that. Service of extensions on protection orders. And I'm just going off my notes here, committee, but I'm trying to verify exactly what we're putting in a bill draft. Title 7 under definition of court is different than under Title 35. And I think that Ms. Butler could probably give us a list of what they had. And then the court had an appointment, the issue of appointing an attorney to represent the petitioner. Are all those topics going to be in that single bill draft and then we amend it as we see fit? Is that what I'm understanding is the motion?
The motion is for at least one bill draft. I think we'll leave it up to the LSO staff to determine whether that best fits in a couple of bills or whether all that can be assimilated into one bill. We may have one specific to domestic violence and a different one for stalking and sexual assault. But I'd like to give them some flexibility in how that product gets portrayed to us, whether it's one or two. Representative Rodriguez-Williams, you took some copious notes, I noticed during that testimony. Are we close on the 5 bullet points?
Yes.
So, Mr. Chairman?
Mr. Co-Chairman.
Just real quickly, in answer to the representative's question, yes, that was the intention of the motion, and I think we got it encompassed. I think we're hopefully there. If not, committee, please raise a hand and we can clarify. But I think the idea is to get a bill draft that reflects some of the feedback we got from the judge and from the administration this morning, and I think we're on it. So.
And Ms. Butler did testify that she would provide some written notes to the LSO to facilitate that. So are we clear on your end, Brian? Representative Provenza?
Thank you, Mr. Chairman. Yeah, I'm clear on what we're doing. I think that there was some discussion on, is it better to extend the period of these the ex parte or the petition process, or to make potentially the protection orders once they've gone through the process of the court permanent, so I guess what I'm asking for, Mr. Chairman, is if we're going down that route of either extending or making it a forever thing, I would like information as to what that can look like or what that looks like in other states. I don't want to go into that discussion blind, given kind of how serious that can be when we're talking about someone's rights and then having to petition to get them back. So I just want to make sure we're making an educated decision at the next meeting. So I'd ask for potentially LSO.
Mr. Fuller, can we make sure we get a staff comment on the options with regards to a lifetime protection order versus the addressing of this tolling and service for extension, all that? Could we get that, make sure that the bill draft reflects those options for us to take up in September?
Yeah, Mr. Chairman, we can. The immediate thought is, in terms of a lifetime, I don't know how much, I mean, structurally that would change those acts. So that may be, I mean, really a different avenue, one that may not fit well in a staff comment, but we'll bring some information on that.
Yeah, Mr. Chairman, I just want to make, then there was the other addition of the concerns with the mailing and being able to mail people. And again, that's another thing I'd like to see what other states have done with that and how that impacts the people that are losing their rights as well as victims.
Right, and I think we can amend, whatever we wish in September. The bill draft just gives us a structure to begin with in September.
So quick,
Mr. Co-Chairman.
just a quick conversation, Mr. Chairman, and I appreciate that we're trying to get this right for the next meeting. We have that outlier that I alluded to, and as we take up these protective orders, I'm not suggesting we pull that bill into our consideration for what we've talked about, but we do have that other bill that we can bring forward, I think, in September and at least look at, either pull it into protective orders bill or not. But I like the fact that we're going to talk about the two things outlined by the representative. I think we're good.
All right, ready for a vote?
Yep.
All in favor of bill draft on protection order, say aye.
Aye.
Those opposed, no? No. That one carries, so we'll have a bill draft. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I move that we create a bill draft on the appeal to district court order to remain in effect pending appeal. And I believe that would be section, state statute 73510, I believe is the one. My concern is I don't want to leave victims in bad positions until a final order denying that an appeal is granted. And so if we can just close that loophole.
Is there a second? Second by Haroldson. Discussion on the motion? Everyone clear on the bill draft request? All those in favor of the bill draft, say aye. 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 Those opposed? Have a bill draft on the continuation of the protection order during a period of appeal. Further, Representative Haroldson.
Thank you, Mr. Chairman. Not probably a bill draft, just a continued conversation as we see this federal court hearing come through and our ex partes, and just, I'd like to have a little more conversation about that, just to make sure we're clear. I don't want to put our judges into a place where they're being asked to do something they don't feel they should be able to do or have to do, and just want to make sure that we're not breaching something we shouldn't be breaching. So just maybe a continued conversation, maybe just a bit of a look into this to see. Obviously, we had legislation brought by this, a good senator last year to maybe address some of that, the seizures and stuff like that, but I don't believe that covers this. And I just want to make sure we maybe have a little bit more communication on that to clarify.
Certainly, and because we have the bill drafts, the whole topic will be on the agenda for September, and we can continue the good work of the committee on protection orders in September. And with that, we'll wrap up our discussion on topic number 2, protection orders. I would like to take about a 5-minute break very quickly, then we'll resume and take up adoption of foster care issues. So we'll stand adjourned for about 5 minutes. Thank you, everyone. We're back from our break. Takes us to topic number 3 this morning, adoption and foster care issues. Ms. Hartley, Mr. Baker, you want to come up to the table, please? So, committee, these folks reached out to me over the past year, telling me about their own personal experiences, and that's what prompted this topic to come up. And so before we hear from the Director of Department of Family Services, I thought we'd set the stage by kind of talking about the issues that beset these families, and then we can consider where we might go from here. So Ms. Hartley, why don't you go first? Lead us off. Tell us your story, if you would.
Good morning. My name is Pat Hartley, and I come to you this morning as a mother and a grandmother. And I appreciate Chairman Washut asking me to share my story with the committee today. I will try to be quick, but I'm here speaking not only for myself, but for many of the grandparents, aunts, and uncles, and other relatives who are raising children that they did not anticipate. My husband and I are grandparents raising our grandchild. Both his mother and father struggled with addiction, were in and out of trouble with law enforcement, and had no capacity to raise our grandchild. When they had him, my grandchild was exposed to drugs, neglected, left in unsafe environments, and much more. My husband and I struggled to figure out how to help. We called DFS, law enforcement, tried everything we could think of to help our child, including sending our adult child to treatment multiple times. From birth to 3, we had our grandson most of the time. We did all the parental things, took him to daycare, school, took care of all his medical needs, bought his clothes, celebrated his birthdays. In every way, he was our child. We finally obtained legal guardianship when he was 3, but were not able to finally adopt him until he was 7. My grandson's mother and father struggled with their addiction and criminal activity the entire time. They would seemingly get clean for a short time, only to start the cycle again, inevitably ending up in trouble. They would disappear off the radar for months, sometimes more than a year, pop back in and then disappear again. It was a cycle that never seemed to end, elongating the legal process, and every time it turned my grandson's world upside down, and often resulted in him losing all the progress he had made emotionally and mentally, being traumatized again and again, losing his sense of security. One thing I would mention is that our experience, DFS and law enforcement did everything they could to protect this child. Every time we called in a report, they would run to a different county or state for a short period of time, making it impossible for anybody to keep tabs on them. I have come to learn that addicts are very adept at hiding and covering things up way more than any of us ever knew, and I certainly didn't know. I used to think we were unique as grandparents. I have come to learn over the years that we're not. The number of children being raised by grandparents like my husband and I, or aunts and uncles, is apparently a growing trend, mostly caused by addiction and the accompanying abuse, neglect, and criminal issues that frequently accompany addiction. Someone told me that there's more than 4,000 grandparents here in Wyoming that are raising their grandchildren. We were lucky. Well, maybe not lucky, but fortunate to meet several of the families at my grandson's schools here in Casper in similar situations. It's hard enough watching your child struggle with abuse, neglect, illegal drug exposure, being constantly in danger, and never having security. My husband and I never hesitated that the best thing was for us to care for him as much as possible. We hoped and prayed every day that his parents would get better, but knew that our grandchild needed stability. The trauma continues today to affect him, even though he's 13. He is still receiving therapy and support, but he didn't really make any forward progress until we finally adopted him. And he calls that the day he got his forever home. What I can share with the committee is that today he is doing well, and we hope that we have put him on a path different from his biological parents. There are many stories like ours, many relatives, mostly grandparents like myself, that have had legal guardianship over a child for more than a year. Many for multiple years, and they can't move forward or are stuck in an endless cycle. One I know has been trying to adopt for more than 2 years, and even though one parent is in jail and the other is deceased, they still are not allowed to move forward. Another has had legal guardianship for almost 4 years and has been told there is no way forward to the court because the parents object. These parents will buy a toy, make a phone call, and that seems to be good enough for the courts to deny adoption. I've come today to ask the committee to take a look at things and see if we can't improve the situation and provide a light at the end of the tunnel. When you talk to any of us that are going through all of this situation, I bet we'll tell you the same thing. There's no light. There are so many challenges that come with raising grandchildren, financial, emotional, mental health challenges, and least of all, but most important, the generation gap. If anybody knows of a class on Snapchat, I'd sure like to take it because I have no clue. The legal expense and length in the process is another challenge. I'm not asking for money. There's been a new group that's recently come to the state called the Wyoming Kinship Connections, and they're working better to support us and the relative caregivers like us. But my hope is that the state can look at the legal process in statute and how we get these kids their forever homes. There are really two options. One is the child is removed by DFS and put in a foster home with essentially strangers. Or two, a family member like myself steps up and takes legal guardianship. The second, I think, is great and shows Wyoming is Wyoming. We always take care of our own. That's one of the things I really love about this state, okay? And that way, we're not putting the burden on the state, okay? The issue is moving forward from that legal guardianship to adoption centers on the termination of rights. I don't know much about the specifics, in all honesty, but if a child is in DFS custody, if the parent has not had what they consider reasonable contact for 15 of the 22 preceding months, DFS terminates the rights of the parent. The child may be adopted or have permanent legal guardians. For us grandparents, that's not an option. There are no parameters like that. Okay, in my own case, again, I don't know if it's called lucky or fortunate, but we were to the point where we needed to do something because the schools would not protect him. They said if his biological parent showed up, he could go out the door with them. So adoption was the only answer. Mom went to prison in Lusk, and Dad fled the state. We finally convinced Mom, while she was in Lusk, to give up her parental rights. When that was done, the courts agreed that we could adopt him. This whole situation took 7 years. living on this roller coaster of not knowing when mom and dad would show up. At one point in time, they showed up at midnight and demanded their child. Okay? Unfortunately, from what I've heard from other grandparents, the court systems in Wyoming handle these cases so differently. Some courts say, oh yes, it's been over a year, it's been 2 years, whatever, and the child is up for adoption. Others say, no, the parents object, so the child cannot be adopted, and there's always that fear on the child's part that mom and dad will come in and swoop them up, okay? I guess there's a few questions to think of. When do the children have rights? When are they allowed to be able to look around and say, this is my home, this is my family, and they don't have to worry about somebody coming in and taking them? If the federal guidelines say 15 months for a petition to terminate rights, shouldn't that be the same for relatives and legal guardians? Shouldn't there be a timeline if a child has if a relative has legal guardianship that wants to adopt? Can't the courts terminate the rights? And please don't get me wrong, I am not in favor of universally parents losing their rights. But at some point in time, we have to look at what's really truly best for the child. Should the court consider that track record, like my adult daughter has? 5 felonies, multiple stints in rehab, mental health illness, and say, yeah, the kid is better off in this stable environment than they would be with this parent. Okay? And maybe I want to say last but least, what happens when the courts come in after 5 years, 10 years, and say, nope, the child has to go back to their parent? They get ripped out of the only home they know. What does that do to that child? My basic 1A logic says that's the thing that's going to cause the next generation of mental health problems, drug addiction, possibly suicide attempts. We need to set up a good process so that way relatives can come take care of these children, and we still have Wyomingites taking care of Wyomingites. Last but not least, one thing that nobody likes to talk about, myself included, is when a family member is entrenched in addiction. They are in and out of jail or prison, and it doesn't affect just the addict. It affects their parents, their children. The amount of impact they have is just horrendous, that most people that luckily don't have to live through this know. As a parent and a grandparent, I truly hope my daughter gets healthy someday and she stays that way. But until then, I'm the only support that my grandson has. And I gladly do it, even though I feel dumb as a rock some days. So I have lived here for a long time, well over 20 years. And I just want to have a way to help Wyoming families. Thank you for your time.
Ms. Hartley, thank you. Thank you very much. I can't imagine all the emotions which you kept in check during that presentation for us today. But I think you really helped, and I know the next presentation will as well, help us understand why this topic is so important for us to consider and get right. And I would just ask if you could leave your notes maybe with the folks at the LSO tables, we could include them in our record. Okay.
Mr.
Baker.
Chairman, I'd love to.
Or stay at the table, there may be questions here in a moment. Mr. Baker, why don't you tell us your story?
Thank you, Mr. Chairman. Honorable Chairman, members of the Joint Committee, I'm here to speak on an injustice that was perpetrated on two little children in 2022. I'm hoping that maybe this testimony can spark a legislative reform to improve a state system that should be better at serving the
Get a
interests
little
of the children.
closer to the microphone.
A little bit closer? Okay. How's that? Is it better? My name is
Nathan
Mr. Baker. I'll do it again now that I've got this closer. I'm here to speak on an injustice that was perpetrated on two little children in 2022. I'm hoping that maybe this testimony can spark a legislative reform to improve a state system that should be better at serving the interests of the children of this state. My wife and I became aware in September 2021 of a pair of young children, aged 2 and 4, in the foster system who were almost certainly going to be in need of adoption. Their permanency plan was being changed to reunification concurrent with adoption. This was the 4-year-old's second time in the foster care system, and they had been voluntarily placed into the foster care system by their biological parents, although they would have been involuntarily taken away anyway. When the authorities arrived, they discovered a filthy mess of a house, children clearly neglected, filthy, and drug needles in a location easily accessible by the children. Their biological father had died, and their biological mother, a drug addict who had been sober a few times before this, had been completely absent from their life since they entered the system in April 2021. We worked hard and became certified foster parents within weeks. This is a process requiring training in child care, trauma care, as well as background checks and a home inspection to make sure it's a suitable location for the child. They're not just put there randomly. And they came to live with us in the latter part of October. We loved the heck out of these kids. I made sure to give them every opportunity we could. We used the money that the state sent us for fostering to pay for them to attend the ECLC at Casper College. We got a membership to the Science Zone and Nicolason Art Museum. Regularly went to those places, along with the Tate and the library. We enrolled them in swimming lessons, dance lessons, and tumbling lessons. We went on vacations together, and they were loved and embraced not just by us, but by our extended family and our church congregation. December came, and we were told that DFS was going to change from the concurrent plan to an adoption plan with termination of the mother's rights. The meeting to change the plan was delayed for a week or so for some reason, and during that brief time, the mother entered rehab. This time she stayed, and after the rehab period ended, reunification was pursued more and more. During this time period, she missed some mandatory drug tests and was let off with a slap on the wrist. She decided that she didn't really need to take medication for her ADHD and depression and stopped doing so. She left job after job and was finally hired to work out at her stepfather's property some distance outside of town. She claimed to be living in an approved house with her step-grandmother, but it quickly became apparent that she was really living out with her stepfather, which is why she was late every time she was supposed to have the children come stay with her at the grandmother's house. She even went so far as to start dating a felon recently convicted for aggravated domestic abuse, introducing him to the children. Even her lawyer told her this was completely unacceptable. The only consequence? Again, a slap on the wrist, and she and the guy both made their Facebook profiles private. I have no idea if she kept seeing him or not. In other words, she met 10 of the 12 factors for unfitness of biological parent, as contained in Wyoming case law, which is included in a packet that I have sent the chair, and you can distribute after this is over. At the permanency hearing, we were fully expecting the appropriate party to file for termination of her rights as required by both federal and state law, since they had been in foster care for 15 of the past 22 months. I will add that it's a travesty of justice that 15 and 22 doesn't apply to relative care. It suspends the timeline. For whatever reason, the concurrent plan was continued rather than termination being filed for. We have since learned that Wyoming has the lowest rate of courts terminating the rights of unfit parents in the entire country. Finally, at the beginning of November 22, after having lived with us for just over a year, they were taken from us and returned to live with their biological mother. We were notified by email 2 days before they were taken. I later found out state law requires a 14-day written notification. We were the only parents the younger child had any memories of. This friendly child, the type who hugs the waitress at the diner, was very cold and distant when first reintroduced to the biological mother. This child repeatedly indicated to everyone involved the desire to stay with us. Even the older child, who did have memories of the biological mother, told their therapist of a wish to live with both us and the biological mother in an ideal world, but if forced to choose, to stay with us. We prepaid the younger child's tumbling lessons for the rest of the school year and offered to keep paying for ECLC for the rest of the semester to make the transition process easier, keep some stability in her life. The older child was now in kindergarten. The biological mother promptly yanked the child out of the ECLC and sent her to some daycare that is apparently run by another step relative. We wonder if that's because they might be less likely to report problems than a place run by a neutral party. We received a call from the tumbling studio asking why the child had not been coming to tumbling lessons since the week after they went back to their biological mother. And they ended up giving us a partial refund when they learned of the situation. Mind you, this tumbling studio was quite close to the daycare, so that would have been a really easy take to there. Finally, although the biological mother and her lawyer had claimed that we were going to be made the legal godparents of the children and that they could come see us anytime they wished, we have heard nothing about from these children since they returned to her. These children are intelligent and curious and social and had such bright futures ahead of them. Now they're kept isolated at the out-of-town property. A year after I first contacted the chairman, the CASA mentioned to us that as soon as DFS closed the case, the oldest child was yanked out of kindergarten to be homeschooled on the computer. And I suspect the younger one was not sent to anywhere either. The one raising them is a lying, manipulative narcissist. Their therapist said she recognizes the type and that she hasn't truly changed who she is, even if she is again sober for who knows how long. These children will almost certainly grow up to be just like their biological parents and perpetuate the cycle of dysfunction to the next generation. While I am personally acquainted with how the system has failed the children in this case, I'm also aware that they are the rule, not the exception. I have talked to other parents who had the children yanked from their living home to be returned to a horrible, dysfunctional, even abusive situation with their biological family. The Christian Science Monitor had an article as long ago as 1999 pointing out that, quote, the majority of children in foster care, 62%, are reunified with their parents, but within a year, half of them are returned to foster care because of new instances of abuse or neglect. Less than a third of children are ever successfully reunited with their parents. Legal reforms such as the Adoption and Safe Families Act of 1997 have increased the number of children adopted from the child welfare system, but adoptions still represent only 10 to 12% of the annual dispositions of children in foster care. I have included an executive brief summary on how well children do in adoption. There's a huge amount of evidence showing the horrible effects these children are going to experience now, growing up in a fatherless home, or worse, a home into which their mother brings some horrible, abusive man like their biological father or the felon she was dating while reunifying with them. Wyoming Statute 14-2-309 discusses the grounds for termination of parent-child relationship. With Section A, Part 5, reading, the child has been in foster care under the responsibility of the state of Wyoming for 15 of the most recent 22 months, and is showing that the parent is unfit to have custody and control of the child. It should be noted that the law says that termination shall be filed, not that it may be filed. It is clear that the bar to show parental unfitness is not defined clearly enough in the statute, and that the best interests of the children are frequently not considered in the decision at all. It's all about the adults. I address you hoping that perhaps something can be done legislatively so that other would-be adoptive parents and the children who love and want to stay with them and would have a much, much better future with them do not have to endure the same injustice and emotional and psychological trauma that my family did. I recommend that the legislature do consider a couple of possibilities. First of all, provide clarity on the ambiguous terminology in the statute, emphasizing for the courts that the good of the child is the paramount consideration. Maybe they should listen to the therapist to come testify. The second thing that would help you as well, I believe, is the legislature consider adopting de facto custodian status into Wyoming law. This is a legal trend that now exists in 34 states and Washington, D.C., where if a young child has spent a year with a caregiving family who treats them like a parent, and that attachment theory shows that they are psychological parents, and it suggests that they be given the same standing as parents in a dispute in a court of law, for example. My wife and I had no standing. We were unable to advocate for these children. That's what I have this morning. There's plenty of stuff in the packet to look at later if you choose to pursue any of this, but thank you for the opportunity to come tell our story.
Thank you for being here this morning. I have shared your information with Ms. Nord and shall share it with the rest of the committee. Thank you. Committee questions. Representative Jennings.
Thank you, Mr. Chairman. My question is mostly for you, ma'am. I've been in this body 10 years. I'm the author of the Parental Rights. And this is a very difficult place because I've heard your stories over and over again. And I think it's, what I personally think is a failing of the government of Wyoming. I think it's a huge problem. The statute is already clear about shall. I mean, to be honest with you, it's already there. And so certainly I'm going to ask DFS and I'm going to ask the judges why in the world they fail that way. On the grandparents' part, I have heard this, and I've a number of people in my district that I've worked with over this very matter. And I've asked the grandparents, did a lawyer, did DFS, did a judge at any time say to you, you should move to terminate the parents' rights? Because we see it over and over again, and we see both sides of it. Lots of grandparents don't want to terminate the parental rights of their children. It's a very controversial thing. It makes the family stress go right up. But in reality, then, when they just have the guardianship, the parent can come back at any time. And what I've heard over my 10 years is that no one in the system ever tells them you should pursue terminating the parental rights. And so my question to you is that, were you ever advised to try and terminate the parental rights? I understand that it's not comfortable for the grandparents. And in your case, it sounds like you probably were willing to and did when it came to that, when the push came to shove. But it seems like that our government is failing, not necessarily in our laws, but that our judges, our DFS, someone is not stepping up to the plate to do this shall terminate the parental rights. And I am huge on parental rights. I've heard the other side of it where grandparents, they don't like the religion that their kids are in, and they've attempted to terminate parental rights over that. And you'll run into things like that. It makes the judge part of it very important. But I guess I'll ask either one of you. The foster care is a little bit different thing. I get that. But for the grandparents, I mean, I think the law is there. I'm not sure that we shouldn't address some issues, but I think there's a breakdown in the government, a failure in our government to actually help grandparents and really help the biological parents. Listen, they're showing a habitual problem that is not helping those grandkids. So that's my question to you, ma'am. Did anyone in the system actually step up early on and say, well, let's not drag this out 7 years? At 2 years, why are we not? I mean, if for DFS we're doing it with a shell at 15 months, why in the world is the system not? Did anyone talk to you about that?
Ms. Hartley?
Mr. Chairman, Representative Jennings, in my personal experience, after being in therapy for 6 months, which my grandson was 3.5 years old, his therapist had visited with mom and dad and looked at me and said, you need to terminate the rights. When we spoke with an attorney, when we could afford it, the attorney said, it'll never go through. It hasn't been 15 months. And I'm like, this child came home to my house when he was born. His mother left the next day and didn't come home for a week. I have always been his mom for all intensive purposes. And this was the status of our relationship. And the attorney's like, it won't go. So in answer to your question, yes, I was advised by both psychiatric professionals and legal professionals that it just couldn't happen.
Representative Jennings.
Thank you, Mr. Chairman. So the advice was, or it sounds to me like the advice from the attorney was that the 15-month period has not lapsed. Were you advised to wait till the 16th month and attempt to do that?
Ms. Hartley?
No, because they said with mom bouncing in and out like she did, it would reset the clock every time. So the court system, because of that, showing up to spend the night at my house or take him to lunch or to the swimming pool, completely reset the clock to a whole new 15 months.
Other questions? Mr. Baker, I saw you nodding your head a couple of times during that response. You want to add anything?
When we inquired about the lack of filing of termination of parent rights, we were told that the same thing, it's not going to go through the court, and it's a horrible thing to lose a TPR case.
All right. Representative Jennings, something more?
Thank you, Mr. Chairman. No, not really a question, a comment. I'd like to apologize for the people of the government of Wyoming failing you.
Okay. Thank you very, very much for being here and bringing this to our attention, and we'll see what we can do. Yes, Mr. Co-Chairman.
I just wanted to echo my appreciation. Thank you both. Thank you for all you did and have done and continue to do. God bless our grandparents. I think you both know how difficult this area of law is. It's difficult on the courts. It's not necessarily a failing, other than a failing of our society, really. I mean, that's what we're dealing with here. But I promise you, we'll sure look into this as a committee. And I know I speak for everyone up here. We would like to find a fix. If there's something we can do to help, we're going to try to find it. Thank you both. Really appreciate it.
Very good. Thank you both. You can wait and hear the rest of the testimony if you wish. Thank you. Director Schmidt? All right, you've heard the testimony that brought us to this point, and please introduce yourselves for the records and be responsive. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the director of the Wyoming Department of Family Services. To my right is Lindsay Schilling. She's the senior administrator for the Social Services Division. First, in comment to the presentations, I appreciate and thank the public presentations. It's a very tough conversation. And I'm very thankful to the many, many grandparents who do step in and take care of their grandchildren, because she's right, there are a lot of grandparents taking care of grandchildren. I also am very grateful for the foster parents who give their time, give their love, give their homes to many of the children that they see that they may not know, that may spend a few nights with them or may spend a few years with them. So important and incredible components of our system over the whole child welfare system. And yes, certainly recognize how difficult it is to take these little ones, even adolescents, into their homes and then watch the system kind of do what it does, sometimes not well. For the presentation today, I'd like to speak, Ms. Schilling's going to speak to more the technical process of how foster care works. It's very much a legal process. Statute dictates a lot of what we do. Federal law dictates a lot of what we do. And we, being the system, DFS often gets held out as the system, but in fact, we're one of the decision makers at the table when it comes to the system. And I think that's an important component to understand, is the role of the multidisciplinary team in this process, and also the role of the courts. So I think Ms. Schilling's is ready to address some of the concerns that were brought up during the testimony as she goes through her presentation, but really just kind of a baseline setting of what it is that we're expected and required to do through the process, if that's okay, Mr. Chairman.
Thank you, Chairman, members of the committee. As the director noted, my name is Lindsay Schilling. I'm the Senior Administrator of the Social Services Division. Before I jump into anything, I also want to call out how important this particular topic is to me. Up until 2019, I was a certified foster parent in Laramie County. We were involved in cases that went really, really well. We also have 3 adopted children at home out of a really difficult case that did not go well. So I've seen it from that side as well, and I certainly do understand the complications of the system and the emotions and the time that go into that. So my presentation today is really just a walk through at a very high level of our foster care system, focusing on the who, what, where, when, and how. And I tried to include, where it was applicable, specific data points to the Wyoming system. So moving on to slide 3. In Wyoming, there are 2 distinct categories of cases supported by DFS, specific to custody status and placement location. We have cases in which children have remained in their home or have returned to their home after a period of an out-of-home placement. We also have cases in which it's been determined that a child cannot safely remain in the home, and that necessitates the need for an out-of-home placement. Under federal and state regulations, foster care is a very broad category of placement. It includes any 24-hour care setting, including the non-relative and relative foster family homes, but group homes, crisis centers, and residential treatment centers as well. In situations when an out-of-home placement is necessary, the preferred placement is always one with a relative when it can be determined to be safe. Prioritizing placement with relatives helps maintain family connections and cultural traditions that hopefully minimize the trauma of the removal. Under federal law, Title 4E, we're required to give preference to adult relatives over non-relatives whenever determining placement for a child. In Wyoming specifically, 2/3 of our open cases supported by the division right now are in-home cases. So cases in which we're supporting families and children who've remained in the home. 1/3 of the cases involve an out-of-home placement. Those out-of-home placement cases tend to be the most complex. Moving on to slide 4, our foster care system is structured a bit differently than other states in that DFS manages both abuse and neglect cases and juvenile justice cases under the same administrative umbrella. As such, foster youth may enter the system in a variety of ways. The Child Protection Act, the Children in Need of Supervision Act, and the Juvenile Justice Act all live in Title 14, as I'm sure you're well aware. But because DFS administers both programs, the provider networks, the certified foster homes, and the community-based service arrays that we have established for our child protective services cases are also equitably available to our juvenile justice cases as well. In many cases, youth may be involved in both a child welfare matter as well as a juvenile delinquency case. These youth are referred to as dual system youth. As of 2016, 7 states had centralized child welfare and juvenile justice administration through a single state-level department. Research is showing that having a single agency accountable for youth increased odds of youth receiving both inpatient and outpatient behavioral health services, and found that interagency data sharing increased odds and improvement of outcomes for both populations. Moving on to slide 5. The Social Services Division, through foster care coordinators in the local field offices, certifies both relative and non-relative foster homes. For initial certification, applicants must be 21 years of age, complete fingerprint-based background checks, 30 hours of training CPR and first aid, and complete a home study. So when people reference the process for becoming a certified foster parent, there is a lot to it. Once certified, foster parents must continue to complete ongoing training and must redo fingerprint background checks every 2 years. In state fiscal year 2024, we had 599 individual foster family homes that included both relative and non-relative homes. Out of all the out-of-home placements in the last 12 months, 73% were focused in foster family homes. Outside of our division, but still within DFS, the substitute care licensing team handles all the licensing and compliance monitoring for all of the in-state group homes, crisis centers, and residential treatment centers. So those providers that we use for foster care in facility settings. Moving on to slide 6. In child protection cases, Wyoming statute 143405 outlines authority for and conditions under which a child can be taken into protective custody. In the state of Wyoming, DFS as an executive branch agency actually does not have authority to take protective custody of a child. That authority is granted to law enforcement. And then in section B of that same paragraph, a physician, physician's assistant, or nurse practitioner when there's reasonable cause to believe there's imminent danger. Similarly, in the Juvenile Delinquency Act.
Just one moment, Mr. Co-Chairman.
So, Ms. Schilling, sorry to interrupt there, but I was just contacted a week ago from somebody saying that dastardly Department of Family Services was responsible for all of this. That's really not the case, if I heard you correctly, and what I believe is you make that recommendation to local law enforcement. Isn't that the way that goes? Can you explain what takes place there?
Ms. Shelley?
You don't have the right to extricate a child from the home, right?
Oh, Mr. Chairman, Senator Landon. So I think in some of our cases, DFS may be contacted ahead of time and asked to provide insight or input into a protective custody determination. I think there are also lots of times when protective custody is initiated based on the emergency situation, and we're contacted after the fact to support with temporary shelter care pending that initial hearing. Okay, a detention or shelter care hearing, as I just referenced, must be held within 48 hours of protective custody in these circumstances. If a court finds that returning the child home is contrary to the welfare of the child, the youth will be ordered into the legal custody of the department. If the court finds that the full-time shelter care or foster care is not necessarily, the court will release the child, but could impose a number of conditions with that youth returning to their home. Any proceeding in a juvenile court is initiated by the filing of a petition. That's done by the county or district attorney. In all 3 acts, the court is required to facilitate the shelter care hearing, may appoint a GAL, and will establish a multidisciplinary team for each of these case types. Moving on to slide 7. Statutory provisions included in the Child Protection Act, the Children in Need of Supervision Act, and the Juvenile Justice Act all require the court to appoint a multidisciplinary team in each circumstance. A 2019 publication from the Children's Bureau confirmed that a multidisciplinary team approach to representing children in child protective cases results in quicker resolution of more cases and better family preservation than a non-disciplinary team approach. A lot of times this is also referred to as team decision-making. And it's a process that's been adopted by more than a dozen states across the country. Per Wyoming statute, MDTs shall include the child's parent, parents or guardian, a representative from the school district, a representative from DFS, the child's psychiatrist or mental health practitioner, the district or county attorney, the child's attorney or guardian ad litem, and a volunteer lay advocate if one's appointed. So for example, CASA in Laramie County, as well as the foster parent. After each quarterly meeting of the MDT, a report is produced summarizing the contents of the meeting. Once all facets of the case have been reviewed, a final recommendation is proposed to the team. Team members can agree, can disagree, or can abstain from providing a position. All positions are noted in a summary report, and the report is provided to the court. ahead of any of the permanency hearings. After reviewing the MDT report, the case documentation, updates received during the hearing, the judge in the court renders the final decision on the recommendations presented in the case and the appropriateness of the permanency plan being recommended. Moving on to slide 8, foster care is a temporary living situation for kids whose parents cannot take care of them. Our main goal of foster care is to ensure that kids are living in a stable, lifelong family, and that hopefully that temporary foster care episode ends once a parent is able to resolve the outstanding risk and safety concerns, or guardian or adoptive family agrees to raise the child involved. Both federal and state law guide our efforts toward prioritizing reunification whenever possible. From state fiscal year 21 to 23, our reunification rate was 72%. Speaking to the 15 of the most recent 22 months, that is language that shows up in Title 4E, as well as the termination of parental rights statute here in Wyoming. Once a youth has been in foster care 15 of the most recent 22 months, federal law encourages formal establishment of an alternative permanency plan. I'd like to add a note here that in a lot of cases, there is a concurrent plan that has already been established before we get to the 15 of the 22 months. So I think there's been usually conversation ahead of that determination as to what the concurrent plan should be. TPR actions are guided by Wyoming statute. It's specifically 142309 outlines circumstances under which the court may be petitioned to terminate parental rights. It is a court proceeding completely separate from the juvenile case. And if upon hearing the petition, the court does not opt to proceed with the termination, it can dismiss the petition altogether or order DFS to continue to make reasonable efforts to rehabilitate the parent for no longer than 6 months after the stay of the petition. Once parental rights have been terminated, there is still a period of time where parents can appeal the court decision for termination. At that time, the court can also consider several different permanency options, including adoption, guardianship, or what we call APLA. It's another planned permanent living arrangement. This is more common for youth over 16 years of age when efforts to establish an adoption or guardianship prior to that have been unsuccessful. Moving on to slide 9. Once a court has adopted a permanency plan of adoption and all parental rights have been terminated, a youth will then be legally free for adoption. As of March 1st, we had 91 youth involved in our cases with a primary permanency plan of adoption, of which 17 were legally free. In many cases, and as was the case in my own situation, the foster family who provided care, if appropriate, will be given an opportunity to adopt a child before additional efforts will be undertaken to locate an alternative pre-adoptive home. Pursuant to our own policy, a child must be in a pre-adoptive placement for 6 months immediately preceding the planned adoption. And if the adoption taking place involves a youth at least 14 years of age, we require written consent from that youth in order to finalize the adoption. For adoptions out of DFS custody, we do have an option of negotiating adoption subsidies to support the ongoing care of that youth. We also have private adoption agencies across the state, and those fall subject to requirements outlined in our substitute care licensing rules. Those rules are really just focused on basic operational administrative requirements. DFS is not party to those adoptions that occur through those private agencies, and we don't provide or negotiate adoption subsidies in these cases. And Chairman, just to follow up on a few of the points that we heard from prior testimony, Kinship Connections of Wyoming was called out as being a program here to help kinship providers. That is a DFS funded and supported program. We really do understand the challenges of KIN providing care for those youth. That program provides referrals and connections to local resources, but also legal support as well for relatives and kin who opt to pursue court action outside of DFS, so that is available. I also wanted to speak just a little bit to the termination of parental rights process and our legal obligation to demonstrate reasonable efforts. There is a court expectation, and certainly many Supreme Court decisions speaking specifically to reasonable efforts of the agency to reunify before a court or a judge will look to terminate parental rights. So while we are definitely part of the process and are the boots on the ground to support the families, the local district attorneys, county attorneys, and certainly the courts play a huge role in how some of those cases flow through. And then I did want to just add a couple of other pieces of information. Our current reentry rate into foster care right now in Wyoming is 6.9%.
Say that one more time, a little louder.
6.9% of children who leave foster care re-enter within the first 12 months. And then I also had collected just our average length and time for our foster care cases. Our CPS cases right now average 13 months, and our probation and juvenile justice cases average 7.8 months from initial petition to case closure and reunification or alternate permanency. And I think with that, we're here to answer.
Thank you, Ms. Shelley. Mr. Co-Chairman.
Well, first of all, thank you, Ms. Schilling, for a lot of information. That was a lot, and all very valuable. But so deep breath now, I just want to have a visit. So given your experience in the foster care world before you joined the administration of DFS and took over as one of the administrators, what would you tell this committee if, on a daily basis, do you run into things that you say, I can't believe we do this, or why can't we change this to make this easier on the folks that we heard from earlier, for example? So just a you and me kind of conversation about what can we do to make this thing better? Because it's very bureaucratic.
If we had a magic wand, Ms. Schilling.
Mr. Chairman, Senator Landon, thank you for that question, and that's an incredibly loaded question. I think when the opportunity came for me to join DFS, knowing that we didn't have the capacity to do any more from a boots on the ground perspective, I think my very first observations in the agency was like, we didn't know what we didn't know. We didn't understand the system. We didn't understand what DFS's roles and responsibilities were. We didn't understand the role of the county attorney as foster parents. We didn't understand the role of the judge and the court in making all of those decisions. I think if we would have understood that, we would have had a better opportunity to advocate and to support the process a little bit differently. It is incredibly challenging. It's a complex system. And I think it's a very fine line between a situation in which, you know, our last case that we were involved in, that mother loved her kids and really legitimately was doing everything she possibly could to right her track. It didn't end up that the kids went back to her, but went back to a relative, but they all live together. Everybody's doing well. I get invited to birthday parties. I keep in touch with the family. The kids that I go home to every night, that was an incredibly challenging case. We were their third foster placement. They had been transitioned several times before that for very good reasons. I mean, that without a doubt absolutely had to happen. But they do still have biofamily. We do try and maintain those connections. It's incredibly difficult. I have absolutely no doubt that as soon as those older kids are 18, they will seek out their bio family. So we're doing the best that we can to support those relationships right now and hopefully prevent, the circle from coming back around.
Ms. Schilling, just
Yeah.
let me interject here. So you gave us a list of things that when you joined the administration, you recognized that you didn't know what you didn't know. You didn't know about the role of the courts and so forth. How many of those have been rectified and how many of those remain as concerns?
So I think from my perspective, the roles and responsibilities are what they always have been. We didn't know about them. We didn't understand the system. We didn't understand the process. We weren't always necessarily clear on what our roles and rights as foster parents were. So I don't know that the system has transitioned much, but certainly seeing it from the other side, I understand why our cases went the way that they did. I understand the decision-making that went behind, a lot of the transitions in the case and the things that happened. So there absolutely are things can be done to streamline the process. And I do think it becomes a conversation on best interests of the children, what's in their best interests versus the parents and the parental rights. But I think from my perspective, an open acknowledgement that not every home looks like my home, and that's okay, and not every parents like I do, and that's okay. And so generally a broader acceptance for different kinds of families and different kinds of homes.
Chairman. Senator Furphy and then Senator Cooper.
Thank you, Mr. Chairman. I would think trying to keep siblings together really complicates things. What is your experience? Are you being able to do that? Thank you, Mr. Chairman.
Ms. Schilling.
Mr. Chairman, Senator Furphy, actually Wyoming does really well in keeping siblings together when it's safe and appropriate to do so. In some of the recent reviews that we've completed, our placement with siblings right now is 92%. And our placement and stability of foster care is 85%. So those are actually two of our top performing areas of the system. I can say through all of the placements of my kids, it was a sibling group of 3. They were together the whole time.
Senator Cooper.
Thank you, Mr. Chairman. Ms. Schilling, is there an advocate within the office today to help the foster parents or the adoptive parents through the process? You understand it, but you understand also how confusing it can be for those of us trying to enter this process. And it doesn't matter if it's in your agency or some of the federal agencies such as Social Security or Medicare, Veterans Administration. It's extremely confusing. So is there somebody within your office specifically to assist these adoptive and foster parents through the process?
Ms. Schilling.
Chairman Senator Cooper, so I would say yes. We have a statewide network of foster care coordinators that are involved at a very local level with supporting initial certification, onboarding. They help with placements. I think there's an opportunity for us there to potentially consider building out maybe support groups or different training in all of the local communities more specific to just the system in general. Not necessarily focused specifically on how to care for the child, but understanding the broader child welfare system. I think that I have that as a takeaway. Maybe we can leverage our foster care coordinators to help that.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. This question would be for either one of you. I was looking at your program, the Kinship Connections program, and it appears that it's a pilot project and only available in 2 counties. I was wondering if you could speak to how well that's being utilized in both of those counties and whether or not expansion is expected statewide, and what does that look like?
Director.
Mr. Chairman, Representative Rodriguez-Williams, it is a pilot right now. We've received some money through the federal government through a lot of the ARPA kind of COVID spending. We did receive notice that we have continued funding federal dollars. We are looking internally to augment that with state general fund so that that program can continue at the level it is. And it's then through funding that we'll be able to expand. It does purchase people. It purchases somebody to do a lot of that work, so that's where the funding goes directly.
Senator Schuler.
Thank you, Mr. Chairman. My question, well, first of all, I'd just like to say I've seen the system work in my county. I actually have a sister who ended up being a foster parent to a little guy that got, well, him and his brother got left, but the mother just took off with the truck driver. And luckily they found the father for the one son. I don't think the other mother, I mean, the little guy who my sister raised, I don't think they even knew who the dad was. But they ended up being foster parents and then ended up, he's 22 years old now, doing well. DFS did everything right in that situation because none of them were related in any way, shape, or form. But so I think there's some success stories out there. I guess my biggest question, particularly after hearing the testimony, the issue with the reasonable contact, is that defined in statute? And is that something maybe we need to take a little closer look at? Because, particularly the one testifier that talked about how they just pop in and out and then that starts the clock over again. I just wonder if maybe that's something we ought to take a really close look at and see if there's something we could do in that realm to make that more reasonable, not just to pop in and out and, hey, I bought him a birthday gift and I'm out the door 2 hours later. I don't know if there's anything at all in statute that, defines that. I should have probably looked it up, but could you answer that?
Ms. Shelley.
Chairman Senator Schuler, so I think you're speaking to reasonable efforts and sort of that judicial determination of reasonableness when it comes to making a determination of terminating rights. And I don't know that there's a clear definition articulated in statute. We certainly rely on case law and Supreme Court decision to sort of gauge our own efforts in supporting reunification, but certainly a worthwhile topic conversation.
Representative Jennings.
Mr. Chairman, thank both of you for being here today. And when I talk about government failure, I'm not saying that anybody intentionally does it, but I have a couple of questions for you. Tagging on to Senator Schuler's a little bit different, and I'm a little more focused towards the grandparents than the foster care, even though they dovetail together, I'm sure. So the theme that I hear over my 10 years is substance abuse and alcohol abuse. Over and over and over again, that seems to be. Do we know the recidivism rate? I mean, like the parent goes to jail, they go for 12 months, they come back, they reset the clock, they do it again, they do it again. The grandparents live through this every time. Do we know those numbers? And then a follow-up.
Mr. Chairman, Representative Jennings, not in a really clear-cut way where we could pull that data. We're in the midst of transferring into a new case management system that will allow us to give better data around those kinds of specific questions. A lot of the information we collect right now is through narrative, which is really hard to give you then a percentage without going through every case. Certainly, mental health and substance use issues are the trickiest cases that we have due to relapse, but also because there is a body of thought about people do relapse during their course of recovery. The balance is how many times do you allow a relapse before it's really impacting the well-being of the child? And so that is a tricky space where reasonable efforts really comes in. Did the agency do everything that the agency should have to engage that family in treatment, to provide the opportunity to access all of those questions? And then at some point, the MDT decides and makes a recommendation saying, we think reasonable efforts have been achieved.
Follow-up?
Follow-up?
Thank you, Mr. Chairman. So I'm very resident to reach in very quickly and move some of these things because of parental rights and the other side of this issue. But as I look at those issues, the mental health, the alcohol and the drug abuse and the apparent recidivism of over and over, the relapse over and over, it seems to me like that might be a place that we would want to touch. And with your experience in DFS and dealing with these hard, because by the time they get to you, families are broken. And we realize that. Would there not be a good mechanism if we're going to touch and change legislation, something along the lines that says, listen, if you have 2 relapses, your parental rights are up for grabs? I mean, we're going to go talk to a judge. Is there something along those lines that you would recommend, because that your experience would show that we might tweak the current parental rights termination type thinking?
Director?
Mr. Chairman, Representative Jennings, I'm not a therapist or a substance use expert, and I think that is a question that maybe should be posed to them. I can tell you at a national level, that conversation is happening across child welfare systems across the US. When's enough enough? Some are looking at extending the 15 of 22 because some of the argument is that maybe that's not enough time for a family to become stable. So the sentiment depends on, I think, who it is that's trying to make that determination. I would be hesitant to offer an expert, this is when I think a person has had enough chances, because I think the family circumstances would dictate that. And so when you put in kind of a hard, fast rule, it then complicates some of those cases where maybe there is a family that's on their way and they need just a little bit more time. But that's really a policy call. I mean, that is a decision then that the system needs to make. I think parents' attorneys might have something different to say as they would come to this body and express some concerns. Certainly mental health and substance use providers, disorder treatment providers may have something else. I do think it's important, though, to go to your point about when we get the families that are already broken. I do think that gave me a little bit of an entryway to talk about doing better for families when we recognize that there are some difficulties and being ready to provide services, the right services at the right time to prevent getting to that point of chaos. And I think the conversation around behavioral health reform that's been happening, the redesign, and thinking more from that time where we encounter a family and being able to access treatment quicker is a long step toward avoiding that eventual heavy hand of the government fully in your business telling you what to do. If we can do better there, I do think then that there's less opportunity for government to get in and have to do what we do, which is very intensive and very intrusive.
Director, just two questions. I know we're running tight on time here, but one is I'd like to hear a little bit about the financial side. Is there a financial incentive for parents to seek reunification so that they can then draw more support from the state, which might enable them to continue with their addictions and so forth, because now they have a revenue stream because they have the kids back in the home? So the financial side of it. And then the question Representative Jennings brought up about the shall. How often do we see the court not reading shall as shall? How often is that timeline adjusted, even though the statute is pretty clear?
Mr. Chairman, to get to the financial question first, is there a financial incentive for parents to have their children home? A lot of the eligibility benefits that we offer are based on household size and children. In terms of where money comes in, the program that we offer that is cash assistance is called TANF. And that's the POWER program where cash assistance is provided for 60 months over the course of the lifetime. At any given time, we have between 500 to 600 households participating in TANF. So the number of households participating in TANF actually getting that cash assistance is pretty low. Of those, half are typically grandparents taking care of grandchildren, as is the case that was discussed today. So the financial incentive to have children back in the home from where we sit in terms of cash assistance isn't that great. Certainly household size for SNAP matters. So there could be some additional SNAP, which is formerly food stamps, some assistance into the home there. Medicaid is not necessarily something that families would experience because children have been reunified. I mean, the children may qualify for Medicaid, but our Medicaid program is limited, so that's not necessarily going to increase a benefit. Another place where there is potential is around housing and HUD housing and that kind of qualification for vouchers. However, I know that there's a bunch of waiting lists for that, so getting into housing is tricky. I don't know if that's necessarily going to incentivize a person wanting their kids back. Those are the cash benefits and the benefits that we're aware of. Child care assistance is another one where there may be a little bit of an incentive, but again, that's going to depend on the qualifying of the parent. The parent has to be working in order to, or seeking jobs in order to get child care assistance. So the benefit programs have a lot of requirements around what the parent should be doing. There isn't that ability to just hang out. I don't know much about SSI and SSD, so disability and those programs. That's a different conversation, certainly, that I could look into if you wanted to know more. So that answers that question, I hope. Okay, so the second question then is the 15 of 22. And I think, and I'm not an attorney, but the 15 of 22 is not a shall, you shall terminate parental rights at 15 of 22. It's you shall establish a permanency plan that then may include the termination of rights at 15 of 22. So that's a guideline that says, in general, if you have a child that's been in care for a period of time, at some point, enough's enough. And this is prior to the 1996 Welfare Act, and there was some federal legislation that came in there. And subsequent to that, which is another piece of federal legislation, that said we cannot let kids linger in foster care. And that's to Representative Jennings' point. At some point, a child has to have some stability. And the 15 of 22 then became kind of that guideline. I don't know if there's any hard science that says 15 of 22 is that perfect spot, and therefore you shall pursue termination of parental rights. Instead, it's permanency planning, meaning you can't just let this kid linger in foster care anymore. You have to make some decisions, system on what the future of this child is. And that can include some other types of permanency, like as Ms. Schilling mentioned, guardianship, or for an older child, APLA, other types of considerations.
So once we have this permanency plan for adoption, can that roll backwards? Can that change? Can the court then come in and say, well, now mom and dad have shown back up and they look better today than they did 9 months ago, so we're going to adjust this permanency plan? That can happen, right?
Mr. Chairman, yes, it can. And I don't have any data on how frequently that occurs, so that goes back to that question about the 15 of 22. how many cases at the 15 of 22 actually go on to some termination of parental rights, and then some permanency versus some sort of reunification or some other type of consent decree. And we can look to see if we can pull that data. That's really court data that we might have to rely on more so than what we have internal to our system, but we'll work with the Supreme Court to see if that's something that we can provide.
I see that as really part of the problem, that if I'm this foster parent and I've fallen in love with these little kiddos and I want to adopt them, and there's a permanency plan for adoption, and so I'm in the pipeline to adopt these kiddos, but as your data showed us, you had 91 with a permanency plan for adoption, only 17 of those were legally cleared for adoption. So that difference are the kids that the foster parents are hoping are going to become theirs, and then at some point, the judge changes because of something in the family dynamic that changes, and they don't get the kids, and the kids get yanked, and they lose that stability, and they go back to the natural family. And I think that's, when I read through the report, that struck in my heart, as saying, you know, I can see where that would just be so painful.
Yes, Mr. Chairman, that is a tremendously difficult period. So some of that is legal. So once the permanency plan is established, and then as Ms. Schilling said, it's a different court action to go to terminate the parental rights. And so we go through, the Attorney General's office represents the state in a lot of those cases. Sometimes county attorneys will represent their own counties as well. And it's a different legal proceeding outside of that determination of the foster care case. So at that point, then it's a different court case, and then there's also provisions there that will allow parents to appeal. So if the judge determines that termination of parental rights is appropriate, issues the termination, then parents have the opportunity to appeal to the Supreme Court. And we do have cases that regularly go to the Supreme Court on appeal. Very infrequently do those terminations get turned over. Most of the time they're upheld, but there have been situations, one even recently, where the district court judge's decision to terminate was overturned by the Supreme Court, and that was sent back to the district court. So yes, it's a legal
There's
risk.
some testimony about variability from district to district in the courts. Is that a good thing, that the judges have that kind of flexibility, or does that point to a problem that maybe we need to address statutorily?
Mr. Chairman, I don't know how big of a problem it is universally. Certainly, there are situations where there are some times where it's a very difficult situation, and maybe permanency doesn't come as quickly or termination doesn't come as quickly as we would like. I'm not sure that happens frequently enough to do a wholesale revision of, or even some revisions of the statute to say you shall. I really am going to defer to the judicial branch to help inform some of that decision, because that is a district court judge's decision. I do think that ongoing and continued training of judges is very helpful in this space. They are courts of general jurisdiction. They are expected to know a lot of things about a lot of stuff. And I do think more attention given to training for district court judges would be helpful in this space. There is an effort through the Supreme Court called the Children's Justice Project that focuses on that, and we work very closely with that project to be able to identify when that happens, or what kind of training needs are being identified. What we could do is certainly look at the outliers and provide that information to you. But as Ms. Schilling pointed out, it's actually in our foster care system that we do pretty well, and permanency does come most of the time within really the frame that we want it to. I think what you hear are a lot of times the cases that are anomalies, and they're heart-wrenching, and they're tough. they're really tough, and the toll it takes on our workers as well as they watch and work with these kids and these families who are struggling. But I do
Senator
think
Chester.
it's outliers.
Thank you, Mr. Chairman. Thank you, Director Schmidt. I have a question about how do we get to the heart of the problem? I think the heart of the problem is that we can't have bright line rules here. I think bright line rules create more trouble than they do solutions. We need to have, the judicial branch needs to have flexibility to do the right thing for the people in front of them, because every situation is different, and a bright line rule, X number of months, you're good. If you're over that, you're bad. I mean, those kind of rules just don't work in these kind of situations. When I was in practice, I didn't really do a lot of domestic relations law, so I'm kind of a novice in this field. So if I ask a dumb question, please correct me. I may make some mistakes here. But what I recall from domestic relations rule law is that when you have a custody dispute, the standard that you need, that the court needs to meet, is what is the best interest of the child. And the placement that they make in a custody determination is what is the best interest of the child. And that has some bearing on the adoption cases as well. But there's another standard here that also there's parental rights. We don't want judges or the system deciding that these are better parents than those parents, and there are parental rights that need to be balanced, and it's a balancing problem that we have the problem here, which is creating all the problem, is how do you find the right balance between the best interest of the child and the rights of the parents, and that's a very tough situation to be in. Now, correct me if I'm wrong, it sounds like from what I've heard from the testimony before and what I've read here, that the best interest of the adoption statutes are sort of lean towards parental rights more so than best interest of the child, and that there's a preference for reunification of the families, and maybe even it might even be in Wyoming statutes 14.3.440 that is the stated objective and the stated preference is to reunify the families. And that might be, in a close case, the family reunification happens when that might turn out to be not the best interest of the child. So I guess, how do we balance best interest of the child versus family reunification? And is there anything that we could do to increase the value of the best interest of the child standard to have that as a greater weight, I guess, in these kinds of decisions? Is there something that you think we might be able to do with that might help solve some of these problems?
Director, is there a point where we can shift that preference?
Mr. Chairman and Representative Chestik, the one component that does really represent the best interests of the child is the appointment of a guardian ad litem. Every child has an attorney that is looking at their best interests. Some communities have CASA workers, which are looking at their best interests beyond their best legal interests. But in Wyoming, we've chosen a guardian ad litem program that looks at both best interests from a legal standpoint and from a well-being standpoint. I also think the multidisciplinary team approach is something that also measures and weighs best interests, as we have mental health therapists that know the children, school that know the children that are also participating in the decision-making about that case. I am not an attorney, and so for me to be able to weigh in and say, here are certain legal elements that you would need to consider in best interest that need to be checked in order for us to know that, I will need to look into that to see if there's some elements from a statutory standpoint that could speak to very much, here's how you document that you're balancing best interests. We're happy to do that, and actually it would be a very interesting exercise. But the system that Wyoming has, compared to a lot of other systems that don't take a multidisciplinary team approach, I think the statute recognizes that there's a lot of people who have an interest in this family, including the family themselves, and tries to incorporate all those people. So through that decision-making process, there really is a strong recommendation in best interests.
Representative Provenza.
Thank you, Mr. Chairman. My question, Director, goes to, I guess, the MDT process. I mean, I'd be curious what kind of discussions are supposed to be had, or like what the goal of each meeting is, how, if there's training or policies that revolve around the MDT. I think we talked about this potentially in 2021. So I just maybe give us enlighten us on that topic. Thank you.
Director.
Mr. Chairman, Representative Provenza, the MDT exists in statute, but there's really nothing that says what an MDT, how an MDT should function. And that may be that point where we talk about what is the role of the MDT and what shall it do and what shall it consider and how frequently should it meet, et cetera. Right now, it's left up from jurisdiction to jurisdiction, and there's no one person on the MDT that's in charge of making sure that the MDT is functioning appropriately. That is possibly a way to be able to provide some better direction for the recommendations that then go to the court. And understanding is the MDT fully vetting everything it should be. But right now, by default, there's nothing in statute that says DFS, you shall coordinate the MDT. A long time ago, just out of self-defense, we started purchasing the services of MDT coordinators because it is a lot of work. But that's just a provision of service. That's not necessarily a dictate as to who should do it, how it should work. We rely sometimes on the courts to tell us that. Sometimes the county attorneys have an opinion. Outside of that, it varies greatly from jurisdiction to jurisdiction.
Thank you. We've passed the agenda time on this topic, but I did see Representative Harrelson had his hand up a moment ago. And I want to see if we have any other public comment on this topic. So Representative Harrelson.
Thank you, Mr. Chairman. I'll keep it quick. Director, thank you for being here with us today. I think we've obviously discussed a ton about this and where this is really going, but I kind of want to slide it back and I want to ask a very simple question and maybe make a bit of a statement with that. Foster care doesn't work without foster families. What's the number one issue we're seeing across the board, at least in our area? A lack of foster families. Why is that? Well, there's a lot of reasons. One of them is the fact that these foster families are sick and tired of being the yo-yo at the end of this process. So I hear a lot of, well, really, it's good, we're really good, this is good. Well, I don't know if the foster families fully agree. My wife and I went through that process. First of all, we need to address the training aspect. It is clunky. It needs to be cleaned up. It's 1980s, and we're not in the 1980s anymore. We could throw it on an app. We could be simple. It could be streamlined. We could clean that up, right? Okay, so let's talk about that. Another thing is this. I mean, we just heard from a foster family who said, you know what, our heart got ripped out, and we're seeing that this isn't the best for these kids. How could you say this is? And I think those things need to be addressed. And is it a situation we already have statute that needs to be enforced differently through the judicial branch? Maybe so. But I think that there has to come a point where we need to go back to the drawing board and say, if we're going to continue to get foster families that are stepping into this process, then we're going to have to understand that there has to be a discussion about what this looks like. Am I off? That's what I'm hearing as I'm sitting back and listening to this conversation. I understand it's a very complicated discussion, but at the end of the day, the discussion, we're going to have a very much different discussion if we burn all of our foster families out. And that we don't want that discussion. So let's just, and maybe, I don't need an answer more than just chew on that as we walk away. And maybe it could be a discussion as we come back.
All right, Director, keep chewing until September. All right, very good. With that, is there anybody else in the room wishing to testify on this issue? Anyone else in this room wishing to testify on public comment? Anybody online for? Okay. With that, I'll close public comment. I'm not sure we've come too far down the road in terms of what we want to do, but I'm hearing pretty clearly that we want this back on the agenda for September.
Mr. Chairman.
Senator Case.
Mr. Chairman, this is a very, very difficult area. And if we're considering knee-jerk solutions, like after 2 times of not showing up, or, you know, you buy junk food and I don't mean that's too trivial, but The thing is, the big hammer that court has in the criminal system are things like deferred prosecution and parole, where, you know, you get one little mess up in parole and you're back in the slammer, right? That's not the model that works here, because they're not adjudicated as criminals. And the courts have already ruled, I think for the most part, I know there are different variances of this that we could learn about, but being a parent is a fundamental right, and it's been interpreted by the courts to have a very, very high standard. And so we are trying, I don't know how that plays out, juxtaposed the rights of the child. I don't. I'd like to learn more about that. But to think that we can say a two-strike, you're out, and it goes, and you're not a parent anymore, that's a pretty big thing that the courts have already probably said, no, you can't do that. So we have to find a way here, but it's not clear to me. And it's, if we're going to have more education from September, I'd love to hear from the courts, because I'm sure the judges go through this like crazy. It's really difficult for them. But knee-jerk solutions aren't going to work.
Representative Provenza.
Thank you, Mr. Chairman. I think for the next meeting, I would like to hear from the courts as well in terms of the MDT process, how often they take the recommendation of the MDT, what are the goals that are outlined by different courts in the MDT? Because I think that kind of sets folks up for, you know, what's our outcome that we want? Is it going to be reunification? Is it, how do we work through that MDT process so we can potentially look at how we can best serve the children in these cases? But I need more information before I do anything with that. I know we've talked about it before, but I'd like to know, again, how we can best serve the MDT process, because I think it is a good one, but maybe it can be improved.
Ms. Butler, I hope you're taking notes. Very good. Mr. Co-Chair.
One quick thing, Mr. Chairman, I didn't ask this because I think we can visit about it a little later, but I was curious about, Ms. Schilling pointed out that other states have different structures in place that, you know, I guess the question would be, is there something we can do differently structurally, organizationally? We're talking about that right now in education, for example, in early childhood, but you know, just because we've always had the same structure all these years, maybe there's something we should be looking at. Maybe we could find out what's going on in some states around us, just out of curiosity more than anything, so.
I saw Mr. Fuller nod his head. I think he caught that one. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I agree in continuing the conversation on this topic. And I'm, a few things that we've discussed that I'm interested in delving a little deeper in is the 15 to 22 months, the shall versus the may, when talking about a permanency plan that may include adoption. And then I was interested in the director's comments on interpretation and relying on prior court cases when it comes to best interest of the child.
Very good. So with that, I'm going to wrap up this topic. I think LSO, we got a good idea of where we're going in September, judicial branch. Okay, so we'll take this topic back up in September, and I just want to, once again, thank Mr. Baker, Mrs. Hartley for being with us today. I think the committee heard your heartfelt testimony and certainly want to find a path to make this better, but I think you understand just how complicated this is. It's got a lot of, like a Rubik's Cube, you know, every twist on the right makes a problem on the left. So thank you all for that very much. So it takes us to our 11:30 topic, the Wyoming Judicial Branch update. We do have a hard break at lunchtime for our working lunch, and so we'll need to move promptly. Ms. Butler.
Mr. Chairman, members of the committee, again, my name is Elisa Butler, and I am the State Court Administrator for the Wyoming Judicial Branch. I had some slides ready, and I think you all have copies of those slides. Of course, I was listening intently and failed to get connected, so I'm not going to present those online, but there are copies in the materials, and I'll just run through those slides with you quickly today, and if you have any questions along the way, please don't hesitate to let me know. What these slides are and what we have for you today is just an update on some of the larger projects that we've been working on within the judicial branch over the last year or so, and just wanted to provide you some additional information of where we're at with those projects, because I believe we have presented them all to you prior to this time. So this is just an update on where things stand. The first one you'll see on slide 1 is the Court Navigator Pilot Program. So this is a project we've been working on, as I said, it was for about a year. We talked with the Wyoming Judicial Council, it was around last June, about implementing a pilot program for a court navigator. What that court navigator would do is basically help self-represented litigants navigate the court system. What we're seeing quite often throughout this state is a couple of different things. One, as I mentioned before, we're living in a legal desert. There are a lot of litigants who would like to get legal services, but they can't find an attorney to help them. And so what they do is they struggle through the court process, not knowing exactly how things work, because it can be fairly complex. The other thing is there are some litigants who either can't afford or don't want to hire an attorney. That doesn't mean that they shouldn't be able to file their case and get heard, have their day in court and get heard by a judge. But when we have self-represented litigants who don't understand the court process, it really tends to bog things down for everyone, including the litigant themselves. So it creates a lot more time with the clerks offices across the state. The judges generally spend quite a bit more time when they're in a hearing kind of explaining, this is how things go, this is what the process looks like, or you haven't done these steps in order to, get to court or get to a hearing today. You have to serve this on, the defendant in the case, or some other defect in the legal process has occurred. And so that creates a lot more time within the courts to get that done. So the Court Navigator is really designed to assist litigants to help them understand the court process a little better and to navigate that court process more effectively and more efficiently. Court navigators right now are volunteers. We are piloting this program right here in Natrona County, and we have recruited volunteers from a number of different entities. The first is right here in Casper College. We're working pretty heavily with the paralegal program here. So we have a few volunteers who are from that paralegal program who are providing court navigator services. We have some actual paralegals in the community who are helping to provide those court navigator services. We're also continuing conversations with the University of Wyoming College of Law, and we've had volunteers from LCCC in Cheyenne and from the AARP. So we've reached out to a number of different entities to find volunteers. We're providing these services both in person and remotely. So we have a space right now in the Townsend Justice Center that is staffed for a few hours a week in person. People can walk in and get those court navigator services. And then we have a way for people to sign up online in order to receive court navigator services. They basically pick a time and they can meet with a court navigator. That navigator will walk them through, again, the court process, what to expect, and if there are any forms that they need to make sure to fill out, how to fill them out appropriately. They do not provide legal advice. These people are not attorneys. Our volunteers, our court navigators are not attorneys. They are not providing legal advice. They're simply helping the litigant navigate the court system. Right now, we have focused the court navigator services on 3 specific areas, and those are the areas that we see self-represented litigants in the most. And those are domestic relations cases, so that includes divorce, custody, child support, forcible entry and detainer cases, so evictions, and then protection order cases. So all 3 of the protection orders that we talked about this morning. As we move forward, what we're looking at is, depending on, and the success, which we hope it's going to be very successful, of this project, we will look at expanding to a more statewide level into different counties throughout the state. And hopefully we will be able to not only provide services to the citizens so that they can better access the court system, but will also help to reduce the burden on clerks and the judges themselves as we assist these self-represented litigants. So, Mr. Chairman, that is the first project that we wanted to provide an update on, and I'd be happy to answer any questions about that one.
Questions on the Navigator programs? Mr. Co-Chairman?
So, Mr. Chairman, and Ms. Butler, how do you know if this, how are you going to know if this is successful? Is it just going to be our judges and our clerks indicating, I think it's working, or do you have some thoughts about that?
Mr. Chairman, Mr. Co-Chairman, we're looking at it in a couple of different ways. So we do ask the litigants themselves to fill out a survey when they're done with the services that we provide to see if they were actually effective and helped them navigate the court system. We've also surveyed the judges and the clerks in Natrona County, and we'll provide a survey later on that will help us kind of look at the two and determine whether or not we've improved. And so those are really qualitative as opposed to quantitative. Quantitative data is going to be a little bit more difficult for a number of reasons. One is tying a litigant to a case. So we don't enter the information from the court navigator into our case management system. Once the case is filed and moves forward by the pro se litigant, we have that, but tying those two together is sometimes difficult. First of all, because we don't actually gather all that much information from the person who's seeking court navigator services. That's by design. We want people to come in and get that help, and they're not always willing to share things that would help us tie those two together. Something like a date of birth, a social security number. Understandably, not everybody wants to provide that information. So we're still working on that piece of data to try to make a more quantitative data point to really show what kind of effect we're having.
All right, your second topic?
Mr. Chairman, the second topic we wanted to provide you an update on was the diversion pilot program or project that is currently being piloted in Campbell County. And the idea behind that was to divert low-level offenders who have serious mental illness away from the justice system and into a treatment type system where they're not being, punished for being severely mentally ill and committing a crime. They do commit crimes, but trying to get them into treatment. And so we don't see this effect of these people with serious mental illness recycling through our court system. And so we've piloted that program, it began in January, and what it does is, as I said, it diverts nonviolent misdemeanants. So these are not felonies, and there's no violence in the charge that's being charged against the person who has committed a crime. It's pre-conviction. And so it's a little bit different than treatment courts. Treatment courts are post-adjudication courts. And so what happens in treatment courts is somebody, is charged with usually a felony. And then if they're convicted, if they plead guilty, then they can go to treatment court after that adjudication rather than, say, going to jail or prison. And they go through the treatment court, and then if they're successful, they graduate out and they avoid a jail or prison sentence. This is a bit different because it happens earlier in the process. And so it's before that adjudication even occurs, and we will identify these people through law enforcement and or at the first appearance in front of a circuit court judge. And so when a defendant comes into a circuit court and the judge says, oh, there's something going on here, then they can try to divert that person to a screening. They get screened by potentially initially a jail, and then could get screened further by a mental health provider in the community. And then if they qualify, which means they have to be a nonviolent misdemeanant, and they have to be the screening has to show that they suffer from one of 5 different serious mental illnesses, including schizophrenia, schizoaffective disorder, major depressive disorder, PTSD, or bipolar disorder. If they if they are screened and shown to suffer from one of those 5, then they are qualified to enter the diversion program. It is a voluntary program. If they agree to enter the diversion program, then their charges are held in abeyance. So they just sit there, and if the person is successful, then those charges will be dismissed. If the person is not successful, then they potentially could go back through the criminal justice system.
Does the prosecutor, in most like 301s, prosecutor has to agree to it? Does prosecutor have to agree to the diversion?
Mr. Chairman, the prosecutor does, although the ability to object is fairly limited by rule. And so the Supreme Court just recently adopted rules around the diversion program. And essentially it says that the prosecutor will agree unless there's good cause not to. They have a real concern about something like the safety of the community. So it does require the prosecutor's consent, but there is a limiting value there. So these individuals will go to treatment. It is a very individualized plan. A lot of times in treatment courts, the treatment is focused on groups. In these kinds of circumstances, because we're looking at these severe mental illnesses, it will require a more individualized kind of case plan, a lot of case management. There will be court supervision, so the defendant who is participating in this plan is required to go back to court once per month in open court, and then they're supposed to have at least 2 contacts with court every month. So there's also, as I said, a lot of case management around these folks, and we've worked really hard with a lot of stakeholders in Campbell County to move this project forward. The behavioral health redesign that's being worked on by the Department of Health right now, I think is going to be a huge asset in moving this project forward, because we do need more community mental health providers providing these kinds of services in order for this diversion model to be successful.
Representative Provenza.
Thank you, Mr. Chairman. Ms. Butler, when you mentioned treatment, where is that occurring? Is that outside of justice placement in a treatment facility or at home? Where is that treatment?
Ms. Butler.
Mr. Chairman, Representative Provenza, what I anticipate is that it just varies depending on the needs of the person that's going through, and it could vary throughout the life of their diversion time. So I anticipate what is happening in Campbell County right now is most of that treatment is outpatient treatment and being done from the person's home. But I would imagine there will be scenarios where that could vary.
Thank you, Mr. Chairman. Very quickly, do you have a sense yet of how many people have entered the program in Campbell County right now?
Mr. Chairman, Representative Chestick, we have had, I believe, just a handful who have entered the program who have agreed to participate. Honestly, I don't have a hard number for you. Right now, today, I think there is 1 who is participating. I think others have come in and out over time. It's a difficult population, and so I think it's going to take a little time for us to get our feet under us.
Okay. Your third topic.
Mr. Chairman, the last topic today is treatment courts, and this is just to provide you with an update on that. And we've talked about this a number of times. This is just the transfer of treatment courts from the Department of Health to the Wyoming Judicial Branch. That will be effective on July 1st of this year. We've worked really collaboratively with the Department of Health in this transition. We will take over a number of things from the Department of Health, including recently the Department of Health implemented a new case management system for the treatment courts statewide. We will adopt that contract and move forward with that case management system. And then we'll also work on some additional things over time. One thing that we will that we're working on right now is implementing new standards for treatment courts. And so those standards, there will be a training for all treatment court staff and judges to understand those standards and how to implement them in each of the treatment courts, and that's going to occur in July. We will also work over the next couple of years on a couple of other things that we'd like to do with treatment courts. One is a certification process for treatment courts where we would expect some reporting on the standards that were adopted, and then certify treatment courts in accordance with those standards. And then the last one is a peer review process, which would allow treatment court personnel to go to another treatment court and basically review what they're doing there. That does a number of things that helps both of the treatment court team personnel understand and learn more about each other, but it also allows them to share ideas and collaborate more effectively rather than having, a state entity come and tell them that they're not doing things right. It's really a much more collaborative process. So those are a few of the things that we'll be working on. And one other thing, Mr. Chairman, just so you all have a heads up, is the Mental Health and Vulnerable Adult Task Force has met twice now, I believe, since the interim. And so there is a bill that the Mental Health Vulnerable Adult Task Force is working on with regard to treatment courts, just a few statutory changes that we think will help streamline that process. So I don't know where that bill will end up, but it's very possible it could end up here. So that is something that task force is working on right now. And Mr. Chairman, with that, I'd be happy to answer any other questions.
Questions, Ms. Butler? Senator Schuler.
Thank you, Mr. Chairman. The biggest question I have is with the transition and obviously the increase in mental health and substance abuse problems, do you feel like the staffing is going to be sufficient for the transition?
Mr. Chairman, Senator Schuler, so we will get one position from the Department of Health to do treatment courts. It is, what we have done is, and this is what the Department of Health did as well, is one person cannot do the entire job of administering treatment courts. It's not possible. And so what happens is the duties are basically given to a bunch of different people on our staff. We received 2 new positions during this last legislative session, and so we'll be looking at how we're going to use those 2 new positions. But moving forward, I think we're going to have to take a hard look about whether or not we need additional staff to administer the treatment courts effectively, and I would anticipate the answer is going to be that we do.
Further questions? Ms. Butler, thank you for the testimony. We're going to run out of time before we do public comment on this topic, so we'll just do public comment very briefly after our lunch break. I believe we have a guest presenter here, getting a nod on the head, so the guest presenter's here. We're going to stand at ease during the lunch hour. Anyone who wishes to stay and be part of the presentation, that's perfectly acceptable. Committee and LSO staff, DoorDash has lunch out in the lobby for us. If you want to grab your sandwiches and come back in here, we will, as soon as we reassemble, we'll begin our lunchtime presentation. So thank you all for a great morning.